Yes.
Malas,
Let the solicitor start. Very well. Let the solicitor.
Section 23. Malas, may I read?
Sir, I am.
Take this mic.
Up and one and go. Lord, I am requesting for our review petition tagged with the main petition.
Huh?
Our review petition may be tagged with the main petition.
Wait. Let us hear the others.
May I?
Yes, please.
May I start from here? I think.
Yes, of course. Your state of Uttar Pradesh.
Yes, State of Uttar Pradesh.
ये क्या चेंज हो गया ऑर्डर?
My lords, I am appearing for the MP Association. Whenever your lordships permit, I'll.
Malas,
Right.
may I start?
Yes.
Malas, may I place 23 for lordships? Pleasure. Any person possessing such minimum qualification as laid down by an academic authority authorized by the central government by notification shall be eligible for appointment as a teacher. Malas will mark that any person possessing such minimum qualification as laid down by an academic authority authorized by the central government by notification shall be eligible for points. So that is one. That does not include TET, Malaj.
That does not include TET.
TET. Malaj, that comes later, Malaj. That's how we would construe it, Malaj, at least from my submission. 2, where a state does not have adequate institutions offering courses or training in teacher education or teaching, teachers possessing minimum qualification as laid down in subsection 1 are not available in sufficient numbers. The central government, if it deems necessary by notification, relax the minimum qualifications required for appointment, academic qualifications, training qualification, provided that a teacher who at the commencement of this act, so this is a proviso, does not possess minimum qualifications laid down and shall secure such minimum qualification within a period of 5 years. Then, provided further that every teacher appointed or in position as on 31st March 2015 who does not possess minimum qualification as laid down in subsection 1 shall acquire such minimum qualifications within a period of 4 years from the date of commencement of the Right to Children Free Education Amendment Act 2017. Well, that's what it says. But Malas will then come to what lordships have observed in the...
What do you make of this? Or in position as on 31st March 2015.
Malas will please come to... Malas, I'll just take Malas through that. Malas will please come to the order, Malas. I'm sorry. Will bear with me, Malas. Impugned order. And what we are aggrieved by. Malas, it has page 214. May I please para 214 of the impugned, page 108.
Just tell us the para number.
Para 214.
214. Yes.
For the detailed discussions above and resting on the same, we hold that the provisions of the RTE Act have to be complied with by all schools as defined in 2N of the RTE, or 2N of the RTE, except the schools established and administered by the minority, whether religious or linguistic, till such time the reference is decided and subject to the answers to the question formulated under section 7. Logically, it would follow that in-service teachers, irrespective of their length of service, would also be required to qualify TET to continue in service. Others will thereafter, will bear with me. However, we are mindful of the ground realities as well as the practical challenges. There are in-service teachers who were recruited, Lordship has obviously recognized that much prior to the advent of RT Act, and who might have put in more than 2 or even 3 decades of service. They have been imparting education to their students to the best of their ability without any serious complaint. It is not that the students who have been imparted education have not shown in life to dislodge such teachers from service on the ground that they have not qualified the TET would seem to be a bit harsh, though we are alive to the settled legal position that operation of statute can never be seen as an evil. Bearing in mind their predicament, we invoke our Article 142 of the Constitution and direct that those teachers who have less than 5 years of service left may continue in service till they attain the age of superannuation without qualifying the TET. However, we make it clear that if any such teacher having less than aspires for promotion, he will not be considered eligible without having qualified TET. Then, Malas, this is insofar as in-service teachers recruited prior to the enactment of the RTE Act and having more than 5 years to retire on superannuation are concerned, they shall be under an obligation to qualify the TET within 2 years from the date in order to continue in service. In any of such teachers fail to qualify the TET within the time we have allowed, they shall have to quit service. Malas will see the section. Lordships have said the proviso. This portion, especially which Lordships have indicated, they shall be on an obligation to qualify TET within 2 years. If any such teachers fail to qualify the TET within that time we have allowed, they shall have to quit service. They may be compulsorily retired and paid whatever terminal benefits they are entitled to. We add a rider to that, qualify for terminal benefits. Such teachers might have put in qualifying period, obviously with qualifying service. If any teacher has not put in qualifying service, well, it's this compulsory retirement and will not be entitled to continue in service. Well, it's my submission. That is not reflected directly what Lordship has said. Well, I can take my law through the notifications and what has happened, but this does not reflect in the section as well. What my lord,
The object of the act, Mr. Solicitor?
the object of the act is right to education, so that well, it's obviously everybody gets
for children. For children.
For children, no doubt.
To exist for the children.
Yes, my lords. But lordships
Don't be so self-centered.
not at all, my lords.
That only I will be getting orders from the court protecting my service. There should be security. But we will not think about the children.
No, not at all, my lords. May I?
You have to give some meaning to the second proviso.
May I?
Please give some meaning to the second proviso.
My lords, it has to be read
The
as
scheme of the act, the statutory scheme was this.
Yes.
Initially, within 5 years, you have to. The legislature was alive to the challenge that there may not be institutions. That is why relaxation was also there.
Yes.
Right? You did not comply.
2-1.
No, you did not qualify the examination.
Yes.
Again, in 2017,
Yes.
the second proviso comes in. Why? What is the purpose of the second proviso?
Well, it's what lordships have also noted at 215 is also extremely important. My lords, the entire basis of what lordships, my
Trying to
understanding.
balance the interests of all
My
the
lords,
teachers.
no, my lords have also considered, and I'm saying this, lordship have genuinely also considered.
2017 gives 4 years,
Yes.
but it is with retrospective effect from 15. So you get only 2 years time, 2017 to 2019. In 2025, we are giving another 2 years time.
Yes. Well, I'm not denying it, but
So the
lordships.
teachers will not
Well, it's- I-
qualify. The
well,
teachers will have
submission
the
is-
right to continue
asks,
giving the second proviso a complete go by.
Malat's ask submission is this. Malat's will
Mr.
again bear with
Solicitor
me.
and all other learned counsel, please throw some light how you overcome this second proviso.
What? 23rd release.
We have kept it for open hearing
Yes.
only for this purpose.
Malat's will come to the 23rd August
So,
notification.
sir, it's para 9 and 10.
Malat's will please come to the which
Para
23rd
9
August
is
2000.
We'll have to decide one after the other.
I'm sorry, Malat's.
Not that solicitor is in the midst of his argument, somebody start.
Malat's will please come to the
We'll take his
notification.
seat, we'll call upon the next.
Malat's will
Not like this. Otherwise, there's
Malas will just bear with me. This was brought into effect by the 23rd August notification, which is page number.
No, this is in the NCT affidavit.
This is in the NCT affidavit, page number 53.
State of UP.
Well,
In
It's part of the NCT affidavit. This is
the main. Submission.
it's not in your review petition, Mr. Solicitor.
I'm sorry.
It's not in your review petition.
It's not. It's quoted. Is it quoted?
No. If it is not there,
इसमें देखिए,
Don't expect us to pick it up from anywhere.
I have
Should have annexed it to the review petition,
maybe
or you should have all come with a compilation of
violation of speech.
the statutory provisions and the notifications,
Notifications, Malad.
so that, we don't have to struggle to find it out.
We won, Malad.
Would I,
Very well. You have made your point that this cannot be given retrospective effect.
And
But I-
Malad, we'll also
Very-
see that it was brought into effect, Malad.
We'll note it.
The NCT notification, page 49 of,
This we can pass.
Malad will, my learned friend.
This cannot be a re-hearing of the entire matter, so let us give chance to
My
the
lord.
council.
Yes.
Right? Mr. Banerjee's submission, we are recording.
Malad, so, Malad, our submission is, it was brought into effect, Malad, in short,
Very well. This is your point.
Malad, one, and it was brought into effect by that 23/8/2010, which has been interpreted by this honorable court saying that it's prospective in application. The exact, Malad, that is also, I'm just mentioning that. Arvind Kumar Yadav,
Give the citation.
Anand Kumar Yadav. Malad, that citation is 2018-13 Supreme Court cases, 560, para 27 and para 28, yes,
27 and
and 28,
very well.
which that's the NCT notification which brings into effect this qualification, and that says it's prospective.
would I assist your lordships?
Malad,
Mr. Jha, please wait for
Yes,
your
ma'am.
turn. Please wait for your turn. You are not here physically. You are
I am
through
grateful,
the
ma'am.
virtual mode, and you want the right
I am
of free
grateful.
audience when there are senior counsel who are enrolled before you in the
I'm
bar.
grateful, my lord. I'm grateful.
Yes, Mr. Divedi, you're the
Yes,
senior most.
yes.
You're
No,
the
I
senior
don't.
most.
Seniority matters, but
No, we'll go by seniority then. We'll go by seniority as per enrollment.
yeah, we want review. Yeah.
Malad,
We'll strictly go by section 23 advocate.
Right. The problem is we don't know our seniority.
You don't know your seniority.
We don't know.
Well, you will have to figure it out.
We'll just take 2 minutes time. Let
It's
me.
3 minutes, sir. We will.
Achha, 2 minutes. 3 minutes.
I'll excuse myself from.
Very
So
good.
Let me-
a very short point. You should just note the point. I'll take
So the
3 or 4
point
minutes.
obvious.
Just one by one.
Yes, 3 or
Mr.
4 minutes.
Bhattacharya, please wait. Let Mr. Dwivedi take 2. Dr. Singh will take. Right.
So kindly have the second proviso, Mullets.
Achha,
Kindly have the second proviso, Mullets.
Mr. R. Dwivedi.
I am appearing for the state of Madhya Pradesh, Mullets. Just bear in mind one fact, not that prior to the enforcement of this act in 2009 and the issuance of the notification under section 23, one by the academic authority on 23rd August 10, we had our own set of rules, Lord, and an examination also for recruiting the teachers. So everybody has, and the qualifications which are prescribed under 2000 and under section 23(1) are substantially similar as in our rules prior to 2009. After 2010 in Madhya Pradesh, everybody has a TET. Question is of not extending this to a point of time prior to the emergence of this act itself, my lords. So I am only, my lord, attempting to draw your lordship's attention to the extension of retrospectivity prior to 2000, this emergence of this act, my lord, and the notification of 23rd August. Now, please see the second proviso.
Yes.
Provided further that every teacher appointed or in position as on 31st March 2015 who does not possess minimum qualifications as laid down under subsection 1. Please mark this expression, as laid down in subsection 1. Now this notification, therefore, this takes us back to 23/1, 2010. So therefore, it is only, Lord, the retrospectivity can be only to the point, Lord, when the qualification was prescribed under 2010. It cannot, Lord, extend to 1998 and 1995, Lord, when the teachers were recruited. If after 2010, there is somebody lacking TET or other qualification, I'm assuming that TET is also qualification. That's what your lordships have observed. I'm not for the moment questioning, Lord, as far as I'm concerned. So assuming TET is there,
Well, thank you.
the TET came in 2010. Before that, we were having our own examinations, Lord, and there was no TET.
Well, it's my, sorry.
So therefore,
Just tell you what I have noted from your petition, State of Madhya Pradesh.
yes, ma'am.
Education is a state subject. There existed state law prior to the coming into force of the
Yes.
RT Act. RT Act does not automatically override the state law. This is one point. Court had no occasion to examine the interplay of RT Act with state laws. Interpretation of court does not align with the statute and rules thereunder, which never intended to apply TET to in-service teachers. SOR of RT 2017 highlights that infrastructure was sought to strengthen the training for the untrained teachers. Intention behind including proviso can never be to apply to in-service teachers. Over 70,000
Your
teachers.
lordships have rightly noted the submissions from them, but I am not pressing, I am not saying, Lord, that after 2009, our state act will continue. I'm not saying that. I'm not saying so.
So,
Please.
for those teachers who have been in service for more than 2 decades, 3 decades, we have provided a relaxation for them depending upon their age.
But this,
Those who are 55 plus, they need not.
but
We have
great,
exercised our one.
with great deference, my lord, second proviso does not, my lord, require.
What do you mean by 31st March 2015, sir?
Lord, that has to be restricted to the notification because it says as provided in subsection 1.
Every teacher notification under 23(1) prescribes the qualifications which every teacher has to possess. Second proviso extends the time period that if you have not acquired the qualification within first 5 years, we are extending it for another 2 years. Otherwise, this proviso does not bear any meaning.
My lord, if it is not extended earlier to this point of time, 23rd August 10, it will be manifestly arbitrary, my lord.
We'll consider.
Lord, kindly just examine, Lord, if today we are required to pass the Bar Council examination after
No,
30
this
years.
argument was raised, Mr. Divedi. This argument was raised before the bench. We had the occasion to consider.
This act does not purport to repeal our state acts and rules retrospectively.
But we'll consider. We are not saying we'll not consider. We'll
No,
consider.
well, it's my.
Dr. Singh,
my
you are for whom?
I am for this entire batch of 2001, 2002, 2003.
In the
Individuals.
individual, what is the name of your client?
301.3. 300 point? 3.1.
Can you give the
30th.
name of the party?
Amit Kumar Singh. That is, will you stop a commentary? 301.30. Amit Kumar Singh. I only have 4 dates to give a lordship. Only 4.
Very well. Amit Kumar Singh.
Yes. You should keep this compilation on the side. My 4 dates are this was. There was, just 4 dates, lordship will note. There were 3rd September 01 regulations.
3rd September?
01. That is well as 25 years ago.
Yes.
In this compilation at page 23 are the extant regulations on that date. I was clearly qualified under them. Please give it to my lords. Page 23. Only 4 dates and 4 documents. Well, I won't take long. And lordship need not go into the merits of it. Just see, glance at it as to whether this is 2001 September. That table, Malas, don't go into the nitty-gritty of it, but they clearly qualified under that. This is my compilation.
You said 3rd September 2000?
1.
This is not there in your compilation? Second, very well. 17 to 24.
Yes. It's relevant parts only I'm showing one is 22 at 23.
22 at 23.
Number 2.
Yes.
Well, number 2, of course, in between now comes on 1st April 2010, the Act, the RTE Act. That date is 1/4/2010.
Yes.
On 23rd of August 2010,
Yes.
a notification is issued requiring the TET. Right, Willis?
Yes.
But it has a significant exemption because they know that there are 50,000 plus teachers like this in the rural areas who don't have this qualification, who have the other one. That is relevant at 31 of this compilation.
30,
Yeah, it starts at 29. You should ignore the rest.
31.
At 31, that exemption is consciously given to protect people like me. Teachers appointed before the date of this notification. Of course, I'm in the hoary past. Even immediately before this is 2010. The following categories of teachers appointed from classes 1 to 8 prior to the date of this notification need not acquire the minimum qualification specified. Then, Malas, a particular category is A. If appointed on or after, then there's a proviso. We are not concerned with that. The third is that this exemption at page 31 is reaffirmed and reiterated at 34. That's my third point. 29th July 2011, Lordship has reached now. That is 1 year after the RTA Act.
Yes.
Justice Banmohan has got 34. On this date, the relevant part of this is at 34 starting, 35 is the relevant part.
Yes.
Teachers, 5A, teachers appointed after the date of this notification in certain cases, where an appropriate government or local authority or a school has issued an advertisement to initiate the process of appointment of teachers prior to the date of this notification. Such appointment may be made in accordance with the NCTE regulations of 2001, which I showed to your lordships. Conscious exemption because they didn't want to penalize people who had done to the best of their ability in the hoary past something, which was then the valid thing. Then, comes the amendment to the Act as the fourth document or the fourth point. That is at 38. 38. That is the NCTE Act amended 38 at 47 is the amendment of 12 capital A. 12 capital A. This is WEF 16/2012. WEF 16/2012. Not sure we got 12A. Justice Banmohan has got 12A. At 47, 38 at 47. 38 at 47.
Yes.
Now, I am interested in the proviso, but your lordship may read the whole. Power of the council to determine minimum standards of education. For the purpose of maintaining standards of education, the council may by regulations determine the qualification of persons who will be recruited as teachers in any pre-primary, primary, upper primary, secondary, senior, so-and-so, intermediate, by whatever name called, run, aided or recognized by central government. Provided, if your lordship doesn't mind, provided that nothing in this section shall adversely affect the continuance of any person recruited in any pre-primary, primary, upper primary, senior, secondary, intermediate, or the colleges under any rule made by the central government, state government, local authority, other authority, immediately before the commencement of the so-and-so Amendment Act of 2011, solely on the ground of non-fulfillment of such qualification as may be specified, provided further that the minimum qualification referred to, etc. These are conscious statutory or delegated legislation exceptions.
No, read further, provided further.
Yes, provided further that the minimum qualification teacher referred to of the first proviso shall be acquired within the period specified in this act or under the Right to Free Act, etc. Correct?
So you will have to acquire it.
No, Malas, now, these are people who have been there, Malas, 50 years.
Maybe the statutory provision is that you have to acquire it. See, the problem that is arising over here, Dr. Singhvi, is precisely this.
But before this amendment.
This proviso says that even the teachers who've been appointed prior in date will have to get this.
That may not be the right interpretation. May I explain why?
See, we have looked at it and my brother has explained it in detail.
So therefore, I am
looking at the act from the perspective of the child. We are saying higher education qualifications of the teachers is required because we must get the best teachers.
So, Malas,
See, unless until you get good quality education, how will the child improve?
so my answer is this.
You have to have good quality
I am
teachers.
requesting my lords to interpret it as a very strong alternative interpretation. This one which your lordship asked me to read is a proviso which will apply to those appointed after the act but before the amendment.
No, that is not so.
Before the amendment. No, but because the amendment says so. That's the contention.
We'll
Please see.
consider.
This is brought by an amendment. It is not brought by the act.
We'll consider.
Obliged.
5 minutes.
Yes.
5 minutes.
What Dr. Singh said, but after.
Just 5 minutes. Lord, kindly,
Who are you for?
I am for Lord. Point 57, Jyoti Singh. So, Lord, if your Lordship have those 4 dates again, without reference to papers.
Jyoti Singh.
Yes. So, Lord, the first relevant date is 1/4/2010. That's the commencement of the Act. The Act of 2009 came into effect on 1/4/10. So prior to 2010, there was no real problem. On 1/4/2010, my lord, there was no TET requirement. The requirement came, my lord, on 23rd August 2010. And then, my lord, is the last date, which is, I think, 23rd of August 2017, when the second proviso, my lord, was added, which takes us back to being in position in 2015. That's, my lord, the conspectus. That's the conspectus. Now, my lord, if your lordship will be pleased to see section 23 and the notification of August 2010. Just see 23 once again.
Yes.
Any persons possessing minimum qualification is laid down by an authority authorized by the government by notification shall be eligible for appointment. So this is, my lord, prospective. Those who are going to be appointed. Then the lordship sees, my lord, the first proviso. Provided a teacher who at the commencement of this act, commencement of the act is 1/4. The commencement is not August. Whoever, my lord, at the commencement of the act, that is a person, my lord, who's already there. So there are 2 different, my lord, groups. Under 23(1), those who are going to be appointed henceforth, and this proviso is those who are already, my lord, in place. Those who are, I'm reading, my lord, that way, those who are teachers who are at the commencement of this act, that is, my lord, on 1/4, do not possess minimum qualifications, under 1 shall acquire. The submission is, my lord, that people like us who were there as on 1/4, we possess the qualification under 23(1) because there was no August. There was no TET. So to say, my lord, that we will be given a grace is wrong because the issue arose in August. So on first principles, those who were in place by virtue of, my lord, this proviso would only be required to fulfill 23(1), and 23(1) on 1/4/10 did not have TET. That's one part. Now, my lord, your lordship may have a look at the notification of August. My lord, your lordship might have it in Mr. Singhvi's compilation.
Mr. Roti has not looked at second proviso. The whole case is on second proviso, not the first proviso.
Second proviso comes in 17. I'll come to that, my lord. Please bear with me. First point I'm making is this proviso does not apply to me.
First proviso, not on the first.
I'm developing the first, then I will go to the notification, then I'll go. Obviously, my lord, if you just read the second, then obviously if you look at it that way, then everything is gone over. What I'm trying to say is, my lord, I was not requiring any grace as on 1/4/2010. In short, I didn't require a grace. I was very much in place with the requirement of relevant qualifications as on, my lord, 1st April 2010, the first submission, without grace. Now, my lord, see,
1st April 2010,
my lord,
the qualifications had not been prescribed.
correct,
Correct?
correct,
It came into existence
August,
on 23rd August 2010.
right,
So therefore, what the first proviso ordains is this.
huh,
If you are a teacher on 1st April 2010,
yeah,
you are given 5 years time to acquire the qualification. From which date 5 years will count? It cannot count from 1st of April 2010 because the qualifications had not been prescribed.
correct,
It will count from the date the qualification is prescribed. That is 23rd August 2010. You have a window of 5 years. 2015, if you don't qualify,
I understand, my lord.
2000,
Yes,
you see, that is why it is again made
my lord,
effective with
I-
retrospective
I-
effect.
I submit.
You are given 2 years time,
I
5 plus 2.
am only saying, my lord,
In
that
fact,
the first proviso talks about commencement of the act.
Mr. Roti, my brother has been very benevolent in giving you some extra time. I was telling him, let the statute operate as it is, and we had a long
All
discussion on
right.
this.
So one more argument. One more argument.
He's been very, very benevolent.
Now, one more argument, my lord, which is based on what your lordships gave me in the order. Kindly turn to the order. Let me read the order first, my lord, and then make the submission. Kindly turn to para 168. 168 of your lordship's judgment.
Paragraph 168.
Yes. NCT 168. The argument is this, my lord. In other words, that the requirement of TET is only for those who were appointed post August 2010. In that light, we were exempt in 2010. My lords will remember, we were exempt under 2010. Can I just show that and then read 168? 168 is completely in my favor. May I read 160?
Read it, but just answer one question.
Yeah.
The requirement gets incorporated on 1st August 2010.
Sorry?
The requirement gets incorporated.
Yes,
on 1st
absolutely right.
So there can be no recruitment after 1st August 2010.
Without that.
If your submission is accepted, then the second proviso will have no relevance. It should never have been there.
So what I'm trying,
Therefore, Mr. Rodki, you're missing the point. The point is of what is the significance of second
my
proviso.
lord, second proviso does not specifically say that the exemption granted until 2010 is gone.
Who are in position on 31st March
Of course.
15, they will have to acquire it.
Mr. Rodki,
So by
the teachers have to upgrade their skills.
Achha,
They
just-
have the best standards for the
I-
teachers.
I-
Examine it from the source.
I've seen, no, I've seen
Let them have the
which
best
I am
teachers.
seeing which way the wind is blowing. So I won't put it another way. I just want to read 168.
Okay.
This is not in my favor. That's why I'm reading it. Para 168. NCT's notification reinforces this requirement by stating that teachers working in unaided schools or those in position as on 31st March 15, like me, my lord, must qualify TET. Now, next para is important. The language of both the RT and the notification leave no room for ambiguity that even those who were appointed prior to RT, like me, if not qualified, must not be TET against me within the grace. Now, look at the next line. Only those appointed prior to so and so in accordance with those applicable rules or covered by specific exemptions. This is in the notification of 2010 are exempt.
Exempted, but thereafter 17 does not grant you that exemption.
You know, if you are
This is the difficulty.
you are exempted and then you take what you give by the left
Yes,
hand, you take it away by the right.
Yes,
What happened?
yes, yes.
You had your fill.
Mr. Gupta, you were there?
You had your fill in the previous round. How many days we heard you?
May I remind you a lot?
5 days.
He should not be stopped, you know.
No.
No, my
but
lord.
Mr. Gupta will hear you because there are other people.
If your lordship is going by seniority, my lord, then Mr. Bikash Bhattacharya should be heard first. Then me, then my lord,
Then
the rest.
others.
Yes.
Very well. We'll go by seniority.
I will keep myself confined specific to the question of Law 23 proviso, second proviso.
Second proviso. Yes.
May I read it, Lord?
Mr. Bhattacharya for whom?
19, 1931 and 39 and 2325.
Now just give the
19
first party's name.
Vidhan Kumar Mondol.
Vidhan Mondol.
আর আমাদের পাঁচ পার্টি
Vidhan Kumar Mondol. Right.
and শ্যামলী হালদার
And Shamali Haldar.
0.31 শ্যামলী হালদার আর
Rashmi.
সোনালী চৌধুরী
Is-
and foreign three names
Vidhan Kumar Mondol. These are separate review petitions.
yes madam three
Shamali and the last one,
সোনালী চৌধুরী
Sonali. Very well. Yes, Mr. Bhattacharya.
The Lord, section 23 Lord, should be read in its entirety.
Right.
Yes. Now, Lord, the first is Lord, the Act desires that there should be prescribed qualification by competent authority. And then say that any person possessing such minimum qualifications as laid down by an academic authority authorized by the central government by notification shall be eligible for appointment as teacher. This is the prospective operation. Now, Second is where state does not have any adequate infrastructure, they will be given 5 years time. Then let's second, provided, the first proviso. A teacher who at the commencement of this act does not possess minimum qualification as laid down under subsection 1 shall acquire such minimum qualifications within a period of 5 years. And then second proviso, provided further, this is important, Lord, we are governed by this, that every teacher appointed or in position as on 31st March 2015, who does not possess minimum qualification as laid down under subsection 1, shall acquire such minimum qualifications within a period of 4 years from the date of commencement of the Right to Children Education Act. Now, our appointment was, my lord, at a point of time when, my lord, the academic qualification was, my lord, determined by the NCTE. And my lord, will kindly turn to, my lord, the
Regulation.
in the matter of, my lord, Anjuman Bidhan. Let kindly turn to, my lord, page 155.
What is that? What is that 155?
155 is the NCTE, my lord, regulation, notification,
Dated
dated 23rd of August.
23rd August 2010.
Yes.
Very well. Yes.
Now, my lord, here, my lord, we'll find, my lord, details are given. Then kindly come to, my lord, at page 157.
You just refer to the regulation number.
Yes.
Because we are looking at this compilation.
The regulation 4. Regulation 4 of,
Regulation 4.
yes, of 23rd August 2010 regulation.
Regulation 4.
Notification.
Notifications.
2010 notification.
Teacher appointed before the date of this notification.
Yes.
Is that the marginal note?
Yes. Teacher
Yes.
appointed before the date of this
This
notification.
notification. Yes.
The following categories of teachers appointed to class 1 to 8 prior to date of this notification need not acquire the minimum qualifications specified in para 1 above.
Right.
A teacher appointed on or after 3rd of September 2001, that is the date on which NCT determination so-and-so regulation 2001 as amended from time to time came into force in accordance with the regulation. And my lord, we are all governed by these. Then my lord, TET was not at all, my lord, a qualification necessary for the purpose of recruitment of teacher, but we had a different training, not TET. Then my lord, kindly turn to, provided that a teacher of class 1 to 5 possessing B.Ed qualification or a teacher possessing B.Ed special, my lord, this is not relevant.
2001 regulation.
Could be. Then my lord will kindly take the trouble to turn to page 163.
Good to hear Bengali in court again.
I'm good.
But that is the inherent resource. Kindly turn to that page 163. That will also clarify the position.
This is what?
29th of July.
29 July 2011.
Yes.
Yes, 29 July 2011.
Yes.
Which clause?
Without kindly turn to without clause 5. Another para 5.
July 2011. Yes, para 5.
For para 5 of the principal notification, the following shall be substituted, namely, teacher appointed after the date of this notification in certain cases where an appropriate government or local authority or school has issued an advertisement to initiate the process of appointment of teachers prior to the date of this notification, such appointments may be made in accordance with the NCT Determination Regulation 2001. Therefore, it is very clear that the NCT had the basic conception in the mind that prior to 2001, the TET qualification was not available, it's not necessary. Then let B. The minimum qualification norms referred to in this notification apply to teachers of language, so and so for different languages. Now, basic thing without that even in 2011, the NCT found that 2001 regulation appointments did not come within the scope of TET. That is one important thing. And if your lordship kindly comes, 2001 regulation, lordship will be pleased to find.
Page number 142. 137.
Let's turn to page 137.
What is that?
2001 regulation.
What is that?
That is the Lord the
3rd September 2001.
সবাই মিলে কথা বললে কোর্ট হবে কি করে?
3rd September 2001.
This is the Lord the qualification regulations may be called National Council for Teachers Education Determination of Minimum Qualifications for Recruitment of Teachers in School Regulations.
So you are referring to which particular regulation?
Kindly see that your lordship will not find date mentioned.
No. Of course, 2001, it was introduced only after the RTE Act.
Right, so.
So 2001 date was unknown.
What
It was unknown.
That's why these notifications gave exemption to the teachers who were appointed prior to the knowledge of date.
Well,
And this exemption was considered by your lordship. Kindly turn to my lord's own judgment.
yes,
Para 168.
that has been placed just now by Mr.
Just, may I just repeat? Kindly, para 168 is very important.
Page 90.
Page 90. Well, I will read it a little slowly for my benefit. Well, I would rather read 167 to my lord's reasoning to arrive at 168. Importantly, the first and second proviso to section 23(2) of the RT Act carve out a transitional obligation for in-service teachers who did not possess the minimum qualifications at the time of commencement of the Act. They were required to acquire such qualification, including passing TET within a prescribed time frame. The second proviso introduced by the RT Act extended this compliance period by a period of 4 years from the date so and so. The express legislative intent was to bring in all service teachers within the ambit of uniform quality standards. Then, NCT's notification also reinforces this requirement by stating that the teachers working in unaided private schools, so those already in position on 31st March 2015, must qualify the TET with the stipulated period. The language of both RT and the notification leaves no room for ambiguity that even those teachers appointed prior to RT, if not qualified, well, this is important, if not qualified, must meet the TET requirement within the grace period. Only those appointed prior to 3rd September 2001 in accordance with the applicable recruitment rules or those covered by specific exceptions were exempted. Well, this is the finding of the Honorable Court, which really supports my cause. But this is my misfortune, but in the direction portion,
This is just noticing the relevant statutory provisions and ultimately 23 subsection 2 second proviso, pins you down.
the second proviso pins me down. I have no quarrel, but that will not empower the.
Because whatever exemption is given under a notification cannot override the statutory provision.
My lord,
NCT cannot grant an exemption which the legislature is not providing. The will of the people has to be respected, Mr. Bhattacharya.
the deepest of respect, that I just
Right? And you are expressing the will of the people
I am
presently.
now. I am trying to point out that the statute says it depends upon the academic authority. It depends on the academic authority.
We will
The
consider.
academic authority felt it. Academic felt it that these people need not go to TET.
Very.
But I can also concede to the extent that if the court feels that they should upgrade their skill, let them do it. But that should not be coterminous with their recruitment. That would be too atrocious.
Very. Thank you.
Lordship,
Yes, Mr.
the
Gupta.
same
I have
benefit
two
that
submissions.
is given to the others, that he may not get promotion.
Right,
But he,
I'll just state the two submissions. First of all,
Who are you appearing for now?
Milord, state of Tamil Nadu,
Just
same,
written by State
yes,
of Tamil
yes.
Nadu. Very well.
And Milord,
We have been hearing in from the morning
yes,
adjournments because
Change
there
of
will be a new problem.
Milord,
New.
your lordship is not going to adjourn this matter, Milord, so we better be here. Now, Milord, I appear in 14 matters, Milord, but the list is there, I don't have
Very
to.
well. First state of Madras.
First state of Tamil Nadu.
State of Tamil Nadu.
2 points, Milord.
Yes.
By directing compulsory retirement, your lordship has interpreted the second proviso in such a way that it introduces an eligibility condition decades after the person went into service. Now, even though this may be for the benefit of the students, it goes against a very fundamental principle of service law, which also must be applied. That's my first submission.
May I take
Second, my lord.
May I take leave?
Second thing is this, my lord. We have given the facts for 4,49,850 teachers in total in the government in my lord, Tamil Nadu. 3,28,701 not qualified under TET. In 2 years' time that your lordship has given us, my lord, it is administratively impossible to repopulate, my lord, the entirety of the service.
Statute gave you 2 years in 2017.
My lord,
We have given 2 years in 2020.
no, my lord, no, my lord.
If your teachers do not equip themselves, Mr. Gupta, we wouldn't expect the state of Tamil Nadu to
My lord, would your lordship, my lord,
come
kindly,
to the
my lord,
teachers.
no,
By now, there may be several lakhs
my lord,
of
just
teachers.
kindly permit me to end my submission.
Right.
The difficulty is, my lord, if it's administratively impossible to repopulate the service, my lord, then the schools have to be shut down. That's what I'm trying to say, my lord. And my lord, your lordship's help,
What happened in 2017 when this notification came?
it wasn't interpreted to mean what your lordship has now said.
It is
Your
very
lordship has
clear.
interpreted
is
it for the
very
first time.
clear. It is very clear.
It may be, my lord,
It
clear
is
to
very
your lordship,
clear,
my lord.
required no interpretation, but the court is forced upon
However,
interpret a plain and simple statutory provision.
all I'm saying, my lord, is kindly give us at least 4 years' time. Otherwise, administratively, my lord, it is impossible and the schools will have to shut down. My lord, this is in grounds 4 and 5 of my review, my lord.
4 years' time.
Yes, my lord.
We'll keep in mind.
Lordship.
Yes, Mr. Patel.
I am for the teachers in the state of Jharkhand.
Achha,
We have-
just 1 minute.
Sorry.
What is the cause title of your petition?
Cause title is Lord Akhil Jharkhand Prathmik Shiksha Sangh.
Akhil
Jharkhand Prathmik Shiksha Sangh. It is
Akhil
301.2.
What number may I?
Point 2. We are teachers, Lord.
Achha. Akhil Jharkhand Prathmik Shikshak Sangh Jharkhand.
Correct.
You have raised 7 points.
Correct.
Oversight of NCT notification which exempted pre-2010 appointees from writing.
I am
test.
starting from
First, court misconstrued RTE Act 17. Intent was never to retrospectively impose TET on teachers appointed prior to 10. Executive clarification dated 3rd August 17 to the effect that teachers appointed prior to 2010 need not acquire this qualification. Rule 9 of RT amendment rules violated. Our interpretation has violated rules very well.
I am not
Pre-2010, this is what we have called out from your petition.
Correct.
Treating pre-2010 appointees with post-2010 appointees amounts to hostile discrimination, violation of 14. Sixth, appointees fulfill the eligibility conditions when they were appointed under the relevant state rules. This is the common submission. And new promotion rules 2025 of the state has granted exemption. So state law will override a central law.
So, Lord, I am not going to argue all that.
So which one
But-
will you argue? Tell us out of these 7.
Lord, I am the point I am essentially placing before your lordships is that your lordships' judgment now, as my learned friend Jaideep just said, your lordships are virtually imposing a new condition of eligibility by a judicial interpretation, which, if possibly the executive had done by a service rule, may have been liable to being struck down by your lordships. And realizing this, my lord, one line of the 2010 notification has been probably overlooked or missed. Please see page 42. We are people who were recruited from 91 to.
You are referring to which regulation?
Yes, please see page 4. I'm
No, we are not looking into every petition because there are more than 100 petitions. It's absolutely impossible to have 100 petitions.
31st March 2010 notification prescribing the qualification.
1st March 2010. It's
No.
not in this compilation. You have a copy.
In your lordship's judgment, I only have a soft copy. In the judgment at page 41, it is reproduced.
Page 41.
41.
Page 40. Just see paragraph number.
Para 62.
Para 60.
The reference comes from para 61. This is under that heading where acts and notifications where your lordship have done. Now, please see para 61. Your lordships have said central government notification dated 31st March 10 appointed NCTE as the academic authority. Then thereafter, the 23rd August 2010 laid down minimum qualification. This is what I am reading. Please have the next page, para 4, teachers appointed before the date of this notification. The following categories of teachers appointed for classes 1 to 7 prior to the date of this notification, we are that class need not acquire the minimum qualifications specified in para 1 above, and C, a teacher appointed before 3rd September 2001 in accordance with the prevalent recruitment rules.
Right.
Now, but this recognizes a very established principle of service jurisprudence which says that your conditions for eligibility for appointment, your lordships have subsequently said promotion will be included in appointment. I have no quarrel with that. Perhaps I may not be able to get promoted till I acquire the TET qualification. But the question is, would my original appointment be also under jeopardy on account of a qualification which is laid almost a decade after or 2 decades after I have come in? And according to me, my lord, the central government has saved us under para 4 subclause C. And once
Notification says prior to the statutory amendment. Statutory amendment has not been challenged.
Hold on,
That is of 2017.
That is the
Para
fresh
69
notification.
Look at para 69 of the judgment.
Correct.
The executive has written a letter.
Correct.
Just turn to para 69.
Yes,
The order, please read it.
I'm reading it.
Yes.
On 3rd August 2017, the Additional Secretary, Ministry of Human Resource Development, Department of School Education and Literacy, issued a letter to the state secretaries reminding them that the last date to acquire minimum qualification is 1st April 2019, and no teacher who did not possess the qualification under the RTE Act would be permitted to continue.
Then-
So, my lord, this would have to be read.
My brother has been more than benevolent.
This
Lord, I-
has been informed as far back as on 17.
I do understand.
Therefore, the executive stand was also this before us,
The-
that this qualification is mandatory. It had to be acquired within 2 years of 2017. My brother has said it's not required for people
I do
retiring
realize, my lord, I was.
within 5 years. Then even till 5 years, you got it in the
My,
next 2
my,
years.
my submission is.
Extension of time.
My submission is that if we are exempted under the basic notification, all subsequent statutory regulations will not come.
That a notification has to yield to the law.
You're not looking at this statutory amendment of the
Statutory
Act.
amendment.
Lord, then
No,
that will
it's a
relate back to
notification.
this act itself. It will not cover a
Statutory
person.
amendment, if it had not had those words, 3rd March or 31st March 2015, we could have interpreted it otherwise. We have put these review petitions only to get assistance from you. How do we interpret
Lord,
the second proviso in a manner different from the
my
one
reading is.
in which we have
My
interpreted?
reading is that if a person is already excluded from this whole new statutory framework, then any subsequent amendment or proviso will not bring him in, my lord. That is all that I'm trying.
That's the next in seniority,
I go in.
Mr. Giri.
Yes,
Very grateful, Lord.
301.8.
What is the name of your client?
Meghraj Singh and others.
Devrat Singh. Madam, dekho to.
Lord, the cost title starts from page 111.
Just one. Devrat Singh. Meghraj Singh.
Yes, my lord.
Meghraj Singh.
My lord, altogether 232 petitioners.
Deprivation of livelihood, retrospective application is irrational. Education is a state subject. State laws predate RTE. Education is a concurrent subject, the state subject. Of notification dated 23rd August 2010 exempted teachers appointed prior to the notification. Proviso to 23(2) provides for acquiring minimum qualifications within 4 years. for teachers appointed prior to coming into force, that was not a minimum qualification. These are the grounds that
These are the grounds. My lord, they have been argued in one way or the other.
it has
Right.
been argued.
And therefore, my lord, why should I
Yes.
take up your lordship's time on that?
Right.
But please come to this section.
Yes.
This is where your lordship seeks some.
Please, we want
Some
assistance on 23
Yes.
to second proviso.
My lord, this is something, my lord, which I am advancing before your lordships. Because this is a manner in which if it is read in this manner, probably many of us come out of the net as such. Please come to section 23 once more.
Yes, we are on 23.
My lord, this was there right from the beginning. That is from 1/4/2010 onwards. Any person possessing such minimum qualifications as laid down by an academic authority. Academic authority, my lord, is also subsequently defined
As NCT.
as NCT. Authorized by the central government by notification shall be eligible for appointment of a teacher as a teacher. My lord, subsection 2 may not strictly apply, but for the sake of completion, let me just read it. Where a state does not have the adequate institutions offering courses or training in teacher education or teachers possessing minimum qualifications as laid down under subsection 1 are not available in sufficient numbers, the central government may, if it deems necessary by notification, relax the minimum qualifications required for appointment as a teacher for such period not exceeding 5 years, as may be specified in the notification. My lord, the second proviso was not there. Probably addition of this or bringing in a qualification, my lord, post prescription of the qualification as per a notification dated 23/10/2010 might have been ultra wise. But your lordships are right. There is a substantive plenary amendment, provided that a teacher who at the commencement of this act does not possess minimum qualifications as laid down under subsection 1 shall acquire such minimum qualifications within a period of 5 years. Suppose we stop with that. Then also, my lord, all those persons, these 232 persons, like several others, they were all appointed prior to 23/10/2010. They were appointed prior to 1/4/2010. There were many of them are appointed in 2001 and up to 2009. Therefore, my lord, the first proviso also does not hit them in that way.
No, it hit them. They did not realize it because they were teachers. It says provided that a teacher,
Yes.
not a person. Person is referred to in 23(1).
Yes.
First proviso does not refer to person.
Yes.
It says provided that a teacher
Yes.
who at the commencement of this act, that means 1st of April 2010,
Yes.
your client is a teacher
Yes.
and does not possess the minimum qualification under 23(1),
Yes.
shall acquire such qualification within a period of 5 years.
That's right.
So you are a teacher in position on 1st April 10. You are given 5 years time to qualify.
My lord, the minimum qualifications laid down in the subsection 1 is by means of a notification.
Right. So
Insofar as the first proviso
that comes on 23rd August 2010.
that's right.
Right? So 5 years cannot be counted from 1st of April. 5 years will obviously have to be counted from the date of the notification.
Correct, my lord.
No, you are a teacher.
No, my submission is this, my lord. My lord, first proviso therefore says, possesses minimum, sorry.
For me, qualification, the minimum qualification established at times.
First proviso therefore says, who at the commencement of this act does not possess minimum, as laid down under subsection 1. Now, who lays down under subsection 1? As per a notification. The notification under subsection 1, which has actually continued to remain from 2010 till date, is a notification dated 23/8/2010. My lord, what your lordships have seen,
These are people who are exempted.
That also covers.
yes, no, my lord. My lord, the 23/8/2010 notification will have to be read into subsection 1. Because subsection 1 contemplates that there has to be a prescription in terms of a notification. If you read the notification dated 23/8/2010 into subsection 1, section 23(1), then proviso, first proviso would also draw sustenance from that.
First proviso may draw sustenance, but the problem is the first proviso uses the expression commencement of this act.
Yes.
Commencement of this act is 1st April 2010,
Yes.
not 1st August 2010.
No.
So therefore, the qualification which is prescribed on 1st April will have to be met by the first proviso. The second proviso is talking about the cutoff date as 31st March 2015.
Can I come
By
to
that time, this
I'll come to
NET qualification has come in.
I'll
Net
come to
qualification has come in.
I'll come to the second proviso in a moment, because I made this submission and my lords felt, I am also hit by subsection, the first proviso.
Both 1, 2.
That's right. Therefore, insofar as 1 is concerned, please read the 23/8/2010 notification into subsection 1 and please have a look at the notification. It's not a question of exemption. Prescription comes under the 23/8/2010.
The second proviso is a complete knockout punch.
No,
you don't forget the background. You're on the background.
Lord, I'll come to the second proviso in a moment.
The second proviso, right?
I'm anyway tottering on the ropes. So, my lord, let me come to the second proviso.
Other council.
I'll just take a minute. I'll just take a minute. I understand, my lord. I'll just take a minute. The notification dated 23/8/2000. This is my submission.
Yes.
Notification dated 23/8/2010 will have to be read into subsection 1. It has to be read into the proviso also. When your lordships read the notification, your lordships will have to, because the prescription contained for minimum qualification in the 23/8/2010, this is where TTE comes in, comes about under the 23/8/2010. There is no plenary statute prescription for TTE. Nowhere. And then when your lordships come to clause 4, training to be undergone, clause 3. Then clause 4, this is also a prescription, not an exemption. The following categories of teachers appointed for classes 1 to 8 prior to the date of this notification need not acquire the minimum qualifications specified in para 1 above. And then, my lord, the prescription comes about. Lord, is it to be construed as an exemption? Because where does 23(1) says exemption? 23(1) says prescription. And prescription would include whatever is mentioned in clause 4. If the prescription contained in clause 4 is...
Was NCT conferred any power to grant exemption?
Lord, if it is not...
How would NCT grant exemption? Being a delegated authority?
No, my lord,
it could not have granted. It could not have granted.
And therefore, my lord...
the parliament, in its wisdom, thought that it is better to make it absolutely clear. Second proviso is inserted with effect from 2017, requiring every teacher in position on 31st March to possess this qualification.
Please come to the second proviso then.
Please read it.
Yes. Provided further that every teacher appointed, Lord, would it mean appointed in terms of the provisions of the Act? Because the Act does not have any retroactive operation. It cannot go beyond 1/4/2010.
In position as
or in position as on the 31st.
Position means not appointed under this Act.
No.
Maybe prior to
Maybe prior to the Act.
My lord, as in or on.
Please, Mr. Giri, we are pointing out. Look at it from the perspective of a child. He needs a good teacher. He needs good quality education. If the teachers are lacking in education, how will they be able to teach the next generation? We have looked at it from this perspective. That's what my brother.
And our
lordships are bound to. No, lordships are bound to look at the holistic picture. We may not be, but I understand, my lord. Therefore, what your lordships are having in mind. But appointed means appointed in terms of the Act. But can the words which come after that, in position on the 31st of March 2015, would it take in persons who were appointed prior to 1/4/2010?
We'll consider.
Who does not possess, yes, my lord, just one moment, my lord. Who does not possess minimum qualifications as laid down under subsection 1. And therefore, my lord, please read the notification again as part of subsection 1. If your lordships are pleased to read it that way, then the qualification that we possessed, which is treated as qualification in terms of the clause 4 of the notification dated 23/8/2010, will have to be treated as sufficient for the purpose of proviso 1 and proviso 2.
Very good. Thank you.
Lord, this is what we wanted to say.
Yes, Mr. Jha. We believe you are next in seniority.
Lord,
Mr. Khushid, you came just now. They have been waiting for some time.
yes, yes.
I'm allowed.
Can I, 30 seconds, Lord.
Oh, he has been sitting right from the beginning. Sorry, very sorry. We didn't see you.
I
Very well. Otherwise,
I didn't know.
we would
Lord,
have
otherwise, I would have given way. Lord. I would
introduced
have
us first. Nobody told us.
given way. I didn't know.
I was asking, I asked my friend to go first. Just at the
Lord, can I just take one more minute, my Lord?
You just now said 30 seconds. And now you make it double.
17-10-2017, there is a notification under 23, under section 18.
17-10-2017.
17-10-2017. It's part of my additional documents.
Very well. What does that
It amends, my Lord, the rules of 2017. There is an explanatory memorandum to this. My Lord, Lordships could always look into the memorandum for the purpose of sustenance, though it doesn't govern it.
Very well.
Last line, my Lord, in the memorandum says, in providing retrospective effect, interests of no person shall be adversely affected.
Very good.
Please bear that in mind also, my Lord, is my receivable.
See, it was interest adversely affected. You want to take a qualification, take it. Prospectively, you can always.
No, Lord, in the thing.
Mr. Jha, we'll call upon you after Mr. Khushid.
My lord, my lord. I'm
Please wait
grateful.
for 2 minutes.
I'm grateful. I'm
My
grateful.
turn, man.
Well, it's grateful. Well,
You appear for whom?
two very short points, Mullahs. I mean, item.
No, not the item. You have to
All
make
right.
the
First
party.
for Meghalaya Sarv Shiksha Abhiyan School.
Meghalaya. मैडम इसमें से मेघालय ढूंढिए ना मैडम कौर नहीं इसमें अलग ऊपर नीचे हो गया है मेघालय व्हाट इज
It's called Meghalaya Sarv Shiksha Abhiyan School.
सर्व शिक्षा
Sarv Shiksha Abhiyan Schools Association.
देखिए तो स्टेट यस स्टेट मेघालय
Mr. Advocate General is here, Mullahs.
सर्व शिक्षा अभियान स्कूल्स एसोसिएशन So, sir, your points raised in the review petition are these.
Please, Mullahs.
There was no TET when the petitioners were appointed in the state of Meghalaya. MHRD's notification dated 3rd August 2017 recognized that the existing in-service elementary teachers who lack the minimum professional qualification should be provided a transitional opportunity for upgradation rather than being summarily removed. Third, the judgment under review conflates both eligibility qualification with quality evaluation. These are the 3
Well,
points.
those are the 3 points. I'm just very briefly going to touch upon 2 issues. One is your Lordship's judgment itself, paragraph 169.
Paragraph 169.
Your Lordship will just allow me to read paragraph 169. It begins at 168 and then 169. Last 3 lines of 168.
This one.
Yes.
Plus, begins with only those appointed prior to 3rd September 2001 in accordance with applicable recruitment rules or those covered by specific exemptions such as special BTC or DEd courses, etc., were exempted. So there was an exemption. Your Lordships have recognized that exemption. People appointed prior to 3rd September 2001. Thereafter, my lords, your Lordships then say, thus read holistically, Section 23 of the RTE Act and the NCTE notifications together establish that TET as a compulsory qualifying criteria for all teachers appointed on or after 23rd of August 2010, and as a time-bound compliance obligation for those appointed earlier without the requisite qualifications. My only submission is requisite qualifications does not include TET, but if your Lordships have written this judgment, your Lordship knows better what exactly it means. But that's my submission, my lords, the way I read it, is that it does not mean TET, it means any other qualification that they don't have, they've been given a compliance period.
Very good. Thank you.
Then, my lords, just through 3 more lines, the sole object is to ensure uniform teaching standards across institutions, etc. We bow to that. My lords, your Lordships have made this point about how does a notification bypass a statute. My lords, but there are 2 statutes involved here. one that I believe has not been taken.
NCT Act,
Because the RTE Act,
RT Act and the NCT Act.
12A and
12A is NCT Act. 12 capital A is of NCT.
12A capital is NCT Act. Because I just want to read out the proviso there. If your lordship will see 12A. Because the proviso only says, provided that nothing in this section shall adversely affect the continuation of any person recruited in a pre-primary, primary, upper primary, secondary, or intermediate schools or colleges under any rule, regulation, or order made by the central government, a state government, Educational Amendment Act 2011, etc., solely on the ground of non-fulfillment of such qualifications as may be specified by the council. The 12A,
Next proviso.
well, I'll read the next. Provided further minimum qualifications of a teacher referred to in the first proviso shall be acquired within a period specified in this act or under right to children to free and compulsory education act. Well, if your lordship read that with my interpretation of paragraph 169, it is qualifications that have to be complied with in that period, but RTE is not part of those qualifications. That's my submission. I'm
Thank you very much.
grateful, my lord.
Yes, Mr. Jha, who do you appear for?
My lord, I appear for the tribal
I have one
No, just-
of
just one.
teachers. And I'm grateful your lordship permitting me to appear.
Yes, please. You are appearing for which state
That's
or?
right. I'm in item number 301.68 for the Tribal Welfare Teacher Association of Madhya Pradesh.
Tribal Welfare Teacher.
So Teachers Association of Madhya
एक बार
Pradesh.
देखिए नहीं इसमें कहाँ है? Tribal Welfare
Teachers Association.
मध्य प्रदेश के आसपास ही होगा.
Yes, ma'am.
अच्छा, point, sir.
My lords, your lordships, I wanted to assist your lordships in interpreting the proviso.
Yes.
Both of them. And since your lordships have positive time, just read it, my lord. Provided that the teacher who at the commencement of this act does not possess the minimum qualifications as laid down under subsection 1 shall acquire such minimum qualifications within a period of 5 years. And the second proviso says that as on 31st March 15, who are there, if they don't possess it, they will acquire it within 4 years. Now, my lord, the section statutory provision says qualifications as laid down under subsection 1. Now, the qualifications that have been laid down under subsection 1 are under the notification of 23rd of August 2010, which your lordships have reproduced, considered on several occasions. But there are certain aspects of it which I want your lordships to just see along with me. Here, my lords, if your lordships will see this notification, there are 4 categories of teachers here, not a single category.
Yes.
The first paragraph, my lord, deals with the qualifications that are prescribed for fresh recruitments after the coming into force of the act. And if your lordships will see under the first paragraph, and TET, which your lordships are concerned, and TET, along with certain qualifications that are mentioned, senior secondary with certain 50%, etc. And in both cases, A and B, it's and TET.
Yes, pass in the teacher eligibility.
Yes, friends. Then if your lordships will turn to paragraph 3 of this notification.
Paragraph 3.
Paragraph 3.
Yes.
Training
to be under.
Yes, madam.
Training to be undergone.
Yes, madam. It says with BA, BSc. Now, this is something apart from what has been mentioned in paragraph 1. BA, BSc with 50%, B.Ed qualification, also eligible for appointment to class 1 to 5 up to January 2012, provided he undergoes NCT recognized 6 months special program elementary education. So even those who don't possess the qualification prescribed in 1 but are BA, BSc with 50%, if they undertake 6 months training, they are qualified. Same is with D.Ed, that is in B. Then 4 comes another set of teachers, my lord. They say the following category of teachers appointed in class 1 to 8 prior to the date of notification need not acquire qualifications specified in 1. And here three instances are given. Teachers were appointed.
But sir, your contention overlooks the minimum qualifications which are prescribed under paragraph number 1. Paragraph number 1 deal with minimum qualifications.
My lord,
Minimum. These may be additional qualifications that are required. Diploma, degree course in teacher education. But the minimum is you must have for classes 1 to 5 secondary or senior secondary or senior secondary. Either of these three plus TET.
Plus TET.
This is for classes 1 to 5. For 6 to 8, you require BA-BSc or again BA-BSc or BA-BSc, senior secondary or senior secondary or BA-BSc. These alternatives are there. But passing TET is the mandatory qualification. You cannot say that if somebody has the qualification in 2, he may not have the qualification in 1.
The reason is, my lord, that the competent authority, that is NCT itself, saying that if these people possess this training, B.Ed, which it has prescribed previously, if they undergo 6 months special training, that is a BTC training which is prescribed there, they will be deemed to possess the qualification prescribed under subsection 123(1). And for these teachers, these 4 categories mentioned in 1, paragraph 1, 3, 4, and there's a 5th category which says that those teachers whose recruitment started prior to the coming into force of the Act and were recruited under the regulations of 2001, they also will not be required to have the qualifications mentioned in para 1. So my respectful submission before your lordships is that the proviso says qualifications laid down in subsection 1.
Yes.
And the qualifications that have been laid down in subsection 1 for us who were working for a very long time is covered either under para 4, 5 or para 3. Para 1. Because there's another very big difficulty in Madhya Pradesh.
Yes.
In Madhya Pradesh, the recruitment rules that were existing at the time when we were appointed did not require 50% in higher secondary for appointment. It was simply higher secondary pass. Now at this stage, if your lordships relegate us to TET, we will not even be eligible to participate in TET because we don't have 90% of the teachers of this association who are working in tribal areas don't even have 50% at that time because they
Our
were
order
only 20
only
years
says
ago.
that you need to qualify in the TET. At this age, you will not be required to go back to the high secondary level and cross 50%.
My submission is
that is not the purport of our order. Our purport of our order is if you are a teacher in position, if you have not acquired TET by now, you do it by 1st of September 2027.
No,
you are not required to go into this 50% higher secondary pass qualification at this stage.
But these authorities, my lord, here in Madhya Pradesh, when they are drawing up people, the list of people who to go through this, they are looking at this 50% qualification and saying you are not qualified.
If they look at it and if you are, if it is applied against you, you may seek your remedies before the appropriate forum.
No,
Thank you very much, Mr. Jha.
No,
Thank you very much.
There's
Who is next?
another issue here.
Just 1 minute. Yes, yes.
One exception. I beg your lordships in that. My lords, in the state of Madhya Pradesh, there are certain scheduled tribes and there are Baigas and others. And when teachers were appointed there, the state government has enacted an act, statutory provisions for tribal welfare. Under that act, these teachers were given exemption from acquiring necessary qualifications for appointment. Now, I'll give a list of teachers who were appointed as teachers and are working there in these tribal areas. They are tribals for the last 20-25 years who do not have this qualification, and they are going to go out simply because now your lordship say that TET has become, though TET is not there in the statutory provision of the Act itself, it's prescribed by the notification. So, my lords, my submission is that these people would go out straight away. And this tribal area where no teacher is willing to go, where schools are not even available, infrastructure is also not there. And these teachers have been, for the last 20-25 years at least,
Well, if there are qualified teachers who cannot be appointed because of dearth of vacancies, definitely they will be going.
nobody is
Notwithstanding
I
that
don't-
the
nobody is
vacancies
willing
in
to
a
go
tribal
in,
area.
nobody is willing to go and work in tribal areas. And that's why, my lords, the non-formal education.
If this submission is accepted, then after 2010, anyway, no teacher
My
can be
lords, this is
appointed
the
for a tribal
factual
area.
situation in
See,
Madhya
this is
Pradesh.
not correct. This is all an emotional argument, no, contrary to law. This cannot be accepted. Then after 2010, no recruitment is taking place for
I
tribal
just
areas.
point out.
Is your submission?
If your lordships will give me a minute, I have filed documents to.
It doesn't sound tenable at all.
My lords, it's not my submission.
No,
It's the government's own stand. I have filed documents to indicate.
Very well. Thank you very much.
We have understood.
Thank you very much. Yes, Meghalaya.
One alternative submission, my lord.
Yes.
We have total 38,256 in service candidates.
How much?
38,526.
38,500?
38,256, my lord.
256.
Out of which we have
You're representing the
state of Meghalaya.
State of Meghalaya.
Yes, my lord.
Very
And out of which we have 5,912 MT80 qualified teachers, my lord.
5,912
5,912
TT qualified.
TT qualified teachers.
Right.
We are holding the examination, my lord, on a regular basis. We would be requesting that some sufficient time may be given so that we can comply with the order. I have
So our order is the
Only
time
for
is
first
31st August 2027.
yes, my lord, 2 years, my lord. We have
2 years.
the
In
issue
2
is
years'
that
time, you conduct two
we
examinations.
have been conducting the examination, but we have got Garos and Khasis region, my lord. Yes, we are holding the examination.
Four exams.
What exams you
The
get?
issue is, my lord, that Garos and Khasis are tribes and we have got the local languages. To filling up those vacancies, my lord, in 2 years may be difficult. We are asking for some more time so that we can comply, my lord.
Well,
I understand
please
the
17 till now, 20.
yes, I understand, my lord, that judgment came on 1st September 2000.
But this was the statutory provision.
Yes, my lord, that I have
We are
seen
only
and I have-
implementing the statutory provision.
yes, my lord. The only difficulty is that if this is implemented, we have
Between Mr. Rahim and Madam Mona, who is senior. Yes.
I only look old, ma'am.
Huh?
I only look old.
You look old.
Or she's just younger.
Lord,
You are for who, madam?
Lord, I am appearing for all postgraduate teachers welfare association item number, Lord,
All postgraduate teachers welfare association.
association item number 30154 301.54 teachers of West Bengal, Lord.
West Bengal.
Yes, my Lord.
1 minute.
Postgraduate on honors, Lord. These teachers are all actually they were recruited for up to higher secondary. Not in West Bengal, your lordship may probably know that there is a category called normal teachers, and there are separate teachers for primary, upper primary.
What normal teachers?
Normal teachers are meant.
I have not heard about normal.
There are notifications by the government also.
What normal teachers, Mr. Rahim? Have you ever heard?
There are notifications. Normal
teachers,
sections.
What is the other category?
Normal sections are.
What
They
is
are,
the other category?
they are called primary and higher secondary. These normal.
No. We have not heard about normal.
Very well, not. These are categories. We were all educated for post-graduation also, for teaching post-graduation also. Our problem is, one problem is a peculiar thing that I will come in the end note. Here, when I am reading section 23, your lordship's first question was, will you please satisfy what is the second proviso up to? I will try not to satisfy that. This will not be applicable.
Please.
But I will read the section again. Any person possessing such minimum qualifications as laid down by an academic authority authorized by the central government by notification shall be eligible for appointment as a teacher. So any person who fulfills will be appointed as a teacher. Where a state does not have adequate institutions offering courses or training in teacher education, or teachers possessing minimum qualifications as laid down in one are not available in sufficient numbers, the central government may, if it deems necessary, by notification, relax the minimum qualifications required for appointment as a teacher for such period not exceeding 5 years as may be specified in that notification. In this, Lord, stopping here for a moment, there are 3 stages at which, Lord, they can extend. One, my lord, when the notification newly coming and the act is new, my lord, then there is no provision by the state giving you more institutions. There are no colleges offering this education. There are no courses or training for this teacher education. Therefore, my lord, this 5-year period from the date of the enactment came in. Now, when within the 5 years also, my lord, provided that a teacher who at the commencement of this act does not possess minimum qualification laid down under subsection 1 shall acquire such minimum qualifications within a period of 5 years. This is what was read in that notification, a subsequent letter which government clarified that this is not applicable to the in-service candidates, which was read out before your lordships. Your lordship's query is provided further that every teacher appointed or in possession as on 31st March 15 who does not possess minimum qualification as laid down under subsection 1 shall acquire such minimum qualifications within a period of 4 years from the date of commencement. Lord, this has been given only with a view to this 15 is a 5-year period which they fixed from 10 to 15. The act came in 2010. It gave the first proviso gave 5 years time to fulfill the qualification. So therefore, my lord, within the 5 years, since there were not many institutions offering this course or not unable to complete the states are coming up and saying we are unable to make up this institution, making them get educated for TET. So the likewise, my lord, it's a new enactment, and since even the new teachers who are recruited and in place in 2015 unable to acquire TUT, therefore, my lord, this proviso 2 was introduced in my humble submission. It is not that a proviso which was actually a benefit which has been granted to in-service candidates could have been again revived by the second proviso. It could not have been revived, my lord. Number 1. And then, my lord, I am only reading the one again, is that a person possessing such minimum qualification as laid down will be eligible for appointment is there. It doesn't say shall be eligible to continue as a teacher. If at all the enactment wanted me to go out when I don't have the TET or the qualification which is prescribed in this section, this section 1 should read like this: shall be eligible for appointment or to continue as a teacher. Since there is no such, my lord, prescription in this enactment, this honorable court, my lord, in my humble submission, could not, my lord, presume a retrospective application of this act. Your lordships are aware, my lord, I can't carry coal to Newcastle. Devin Katti principle, which is till date may not pursue, followed by this honorable court, is that when an advertisement is issued and somebody is recruited, you have to only go by the rules then in existence. You can't subsequently, after a person joins a service, you cannot now retrospectively apply a rule which is now introduced. And then, my lord, for the basic service law principle, my lord, this will be, if this interpretation, if it is given, that even to continue as a teacher, this provision will be applicable, will be contrary to the basic principles, in my humble submission. Your lordship will also...
Thank you, madam.
Lord, just one more minute.
Thank
Lord, the normal section is what the West Bengal says, is that, Lord, our appointment itself is for the High Court judgment also in several cases mentioned, that is a normal section will include from 5 to 10, Lord, class 5 to 10. The peculiar problem for West Bengal teachers today is that, we were teaching up to 10th. In fact, we can teach higher secondary also. But due to this bifurcation, now they are made to teach only upper primary, asking me to now get TET qualification, which is peculiar to West Bengal, secondary. So therefore, we have a problem.
Thank you, madam. Yes, Mr. Ryan. Who else is there senior to you?
Who is of course also retired.
I'm simply
Acha,
301.62.
Acha. You are appealing for?
301.62 intervention applications on behalf of the teachers. Lot of arguments have been argued, my lord. Only this, your lordship has also said, pointed out in the para.
This is this serial number?
301.62 intervention
application in 301.62.
On behalf of
Yes,
teachers,
yes,
700 teachers.
Yes, please.
Prior to 2001, they were appointed. And in para 62, your lordship has already quoted, and that has been argued. 4, and there is an exemption of TET. My submission is this, that we are exempted in accordance with that. TET is not required. Second point is this, that Article 309.11.2, it is a status and it cannot be taken away. The main argument is, as I was hearing, that looking to the teachers' efficiency, this examination is necessary. It is a dangerous trend. It can be in every service. That is the main point.
21A has been brought in with a purpose.
So, my lord, then to every service.
Very well. Yes, Mr. D.S. Naidu now.
May it please, Minister. Minister, I represent the teachers from the state of West Bengal, and they were all please.
Mr. Rahim, Mr.
No, no, I-
Madam Mona, you also.
Yes,
Only 1 minute.
Lord, it just shows me, Lord, that the teachers over there. It just shows me, Lord, that the apathy of the teachers over there. How they are.
Because my lord, the state of West Bengal and board has not come out.
Nice.
Minister,
Well, just 1 minute. Let Mr. Naidu come. Today we will not.
if I'm permitted 30 seconds, Minister,
Yes, yes.
if I'm
1
permitted.
minute.
No, Minister.
1 minute. No. Because we are hearing the same argument again and again.
Yes.
We have been indulgent, but that does not mean Mr. Naidu.
Absolutely, Minister.
Right,
I can
that
never
same
hold
argument
to your
will
lordship's
be,
kindness. But my lords
presented
have
for us in a different language. Just 1 minute. This is a review. We have heard from 2 o'clock, right?
We're all great.
The review, the error has to be such that it does not require more than a minute's argument to demonstrate.
Precisely, Minister. Would my lords have, since I have taken the SCC copy of your lordship judgment?
No, we have the SCC copy.
Yes, Minister. Could my lords come to para 90?
90.
90.
That is the
That
bedrock of the
permeates.
judgment.
That permeates.
90 is the bedrock of the judgment.
Indeed, my lord. That's why I begin with that one. That permeates the spirit of the judgment. And my lords have taken recourse to, in my humble submission, a purposive interpretation coupled with Hayden's principle of curing a mischief. This is one thing. And Millets, the question that I may have to pose myself is this, Millets. Can a qualification which has not been explicit be read into any recruitment process?
2017, this proviso was brought in,
Yes, Millets.
right? Why did you not challenge it?
Obviously, Millets.
Why
my
did you
humble
teachers not
submission is-
challenge it?
My humble.
Just tell us this.
Yes.
It has been almost 9 years on the statute book. The parliament wanted to give 4 years time, but it is brought into effect with retrospective effect from 15, thereby curtailing that 4 in by 2 years. And even then,
My
West
answer.
Bengal teachers, they did not rise from their slumber.
My answer is this, Millets.
Now everybody.
We have never.
Now everybody, what now everybody? What is the,
Millets.
if we interpret the law as you are asking us to interpret, this second proviso will be rendered redundant.
May I say with great respect, Millets,
Redundant.
the only difference between first proviso and second proviso, as I understood, was that, Millets, whatever the time frame that was given, there were representations from various states,
extended.
and it was extended. So, the first proviso, if good enough, the second proviso is only otious, except to certain categories of extension of
Second
time.
proviso makes it absolutely clear.
It's been made explicit, Millets. It's been
Whatever
made explicit what is
ambiguity was
inside.
there in first proviso,
Yes, Millets. It's only clarificatory nature rather than giving anything extra, barring the time frame that's been extended. My humble submission is this, Millets, that has been repeated, that the section does not, rather the article and the section, they do not read anything vis-a-vis the qualification or minimum qualification. I was recruited, we were all recruited for that matter, between 2001 and 2010. Then Millet's 2010 rules superseded. Then 2011, there was an amendment. Eventually, 2014 was the culminating factor. Millet's amendment or no amendment, my submission is this, Millet's. All through, I've been qualified when I was recruited. And Millet's, I've had a vested right in the process of my recruitment and my appointment. And Millet's, any rule or regulation which has come in effect, if that supersedes something else, Millet's, the vested right in terms of Section 6 of General Clauses Act cannot be diluted. This is my humble submission.
Lord, only Lord, I will not repeat anything, Lord. I will not repeat anything. Lord, your Lordship may kindly see, Lord, your Lordship, Lord, at the heart of the judgment, my Lord, is the fact that your Lordship wanted, my Lord, uniform teaching qualifications, A, and your Lordship said, my Lord, that TET is a constitutional assessment, for which reason, my Lord, Article 21A, and, my Lord, the provisor, my Lord, your Lordships have, my Lord, held it very firmly, my Lord, and rightly so, my Lord. Now, my Lord, today, my Lord, the ground reality is this, my Lord. In Bengal, my Lord, Lord, the first state was held in 2014. No,
the exam will change now.
No,
hopefully.
I'm saying,
Hopefully.
we all pray for that. We all pray for a better.
Let us hope for the
Yes,
change.
of course, we would.
There is an order.
Yes, sir.
There is an order of this court. 2027 is the deadline.
So, my lord, if your lordship, my lord, say the second was held, why these people did not come? My lord, the second was held after 7 years, 2021. A part. B is, my lord, if your lordship sees, my lord, your lordship.
Everyone was looting the state.
But that, my lord, the teachers.
So now let us hope for a better future.
We always have to, my lord, look to a future, to a dawn.
I can appreciate
only 2-3
this
things.
happened almost 20 years ago. By then, it was not in
Only
contemplation.
2-3 things.
Neither the constitutional amendment or the enactment, neither of them was there. my lord.
The word which was troubling your lordship was, my lord, if your lordship sees, my lord, your lordship has seen 23:1, my lord. Your lordship said, my lord, any person, and you were not a teacher at that point of time. But if your lordship sees, my lord, the proviso, my lord, the first proviso. So provided that a teacher, now the word person here, my lord, should be read to mean a teacher. Provided that a teacher.
Sir, 23:1.
Yes, my lord.
At the risk of repetition, we are saying 23:1 says,
Yes, my lord.
any person who wants to be a teacher
Please.
must have the qualifications under 23:1.
Correct.
Any person who wants to be a teacher. And first proviso says a teacher. So that presupposes that you're already in service. So if you're in service, you're given 5 years time to upgrade yourself.
To give.
My lord, there were instances, if I may add, my lord, there were instances when relaxations were made. My
Like
lord,
a broken record, we have been repeating the same
No,
thing
my lord.
again.
There were instances when states represented to the central authority
I will only
that
reiterate
because we don't have the wherewithal, it should be exempted. Such
there are
categories which have been exempted from minimum qualification, they were given this opportunity, not the ones who had the qualification by word go.
Could it be 4 years, my lord?
Why we didn't challenge it? There's a letter of 2017. The amendment of 2017. Now,
Whose letter?
This is already there. 6 months.
MHRD's letter, which reflects
What is the date?
3rd of August 2017. The amendment came on 10th of August 2017. Now, this letter of MHRD,
3rd of August 2017. What did it say? Just tell us.
it laid down detailed guidelines to all states and union territories about gaining the qualification required and to meet the deadline. And the only thing it referred to and discussed in detail is getting a DLED, which is a diploma in elementary education. And this, your lordship, the reason why this is important, I tell your lordships, Regulation 5, your lordship will again, I'm sorry to say, read Regulation 5 of NCT 2010 regulations. Regulation 5 very categorically says that those regulations.
Can you please come to para 69 of our order?
Yes, your lordship.
Have we read 3rd August 2017 erroneously?
I tell your lordship, fine.
Just tell us that.
Yes, sir.
Just look into 69. Have we read the 3rd August 17 order erroneously?
No, but the question is,
We have said, Madam, just see 69.
what were the
Additional Secretary MHRD issued a letter to the state secretaries reminding that the last date to acquire minimum qualifications is 1st April 19, and no teacher who did not possess minimum qualifications under RT would be permitted to continue in service beyond the given date. Is it a wrong interpretation of the letter?
No, lordship did not interpret the letter. Your lordship merely said minimum qualifications. But what are the minimum qualifications? The question. There are 22 steps which the 2017 letter talks about. Everything involves diploma in elementary education and online distance courses for diploma in elementary education. There is not a whisper about TET in that.
Very good.
And I'll tell you, lordships, why their understanding is. That understanding is in consonance with Regulation 5 of 23rd of August 2010. Your lordship, just read Regulation 5 once again. I know your lordship has read it. It very categorically says, where an appropriate government or local authority or a school has issued an advertisement to initiate the process of appointment of teachers prior to the date of this notification, such appointments may be made in accordance with NCT 2001 regulations. Under Section 23, the gold standard is NCTE. 23 does not say what your minimum standards are. 23 says NCT will lay down minimum standards. Rightly or wrongly, NCT 2010 has two categories. Those who are prior to the notification, those who are post-notification. Whether it is in one way or the other, that is a law. NCT 2010 is a law. it is in consonance both with 12A of NCT Act as well as RT. It is not contrary to either. NCT 2010 notification creates two categories. Those who are appointment prior to the notification date and post notification date. Prior to 2010 notification date, they say the standards and qualification of 2001 will apply. Post 2010 notification, 2010 will apply. So all those who are selected prior to a selection process prior to 2010 are governed by NCT 2001. It does not mean there are no standards.
Thank you.
And that
Anyone else?
They form a different class when it comes to 2000 up to 2010 means.
My lord,
Form a different class.
my lord, I have appearing for Women Teachers Association.
2010 may be a justification.
The TET exam be held after every 6 months, my lord. Otherwise,
I am appearing for UP Women
Mr. Right.
Association. UP Women Association, my lord, of teachers of UP, my lord. My lord, the only one, first of all, my lord, there should be a schedule in which, my lord, the states have to conduct these exams, my lord, so that all the backlog may be cleared, my lord. That is the first, my lord. And secondly, my lord,
in case they are not holding the exam within time, you are at liberty to approach the court. The problem is,
my lord, it doesn't happen, my lord. My lord, if it is a part of the order, my lord, they will listen to it, my lord. And then, my lord, JD members, my lord.
You find you are here right from the beginning.
Yes, my lord.
What did Tamil Nadu say?
Yes, my lord. They said 4 years, my lord. Then my lordship accepted.
No, because they say that if the teachers in position they don't qualify, we will be without
schools will be
teachers.
closed, my lord. Yes.
So whose duty it is to hold the TET under the law?
States, my lord, but they
States.
yes, my lord.
Now, state on the one hand will say that don't require TT to be acquired by the teachers. On the other hand, they will say that we will be out of teachers.
Yes,
What is
my lord,
this?
lakhs of vacancies are there, my lord, in the schools, my lord. They are not.
There are lakhs and lakhs of individuals who have qualified TET and are waiting in the wings. Let them be examined. Let them be assessed.
Yes, my lord, I'm only praying, my lord, to give some exemptions to ladies, my lord.
Sorry?
Some exemption to ladies.
Ladies are in our judicial service more than 50%. And you want exemption for ladies?
My lord, now the situation is different.
Just see the judgment authored by Brother Manmohan in Ashrur Kaur.
Yes, said now their time has come and there will be reservation for men.
My lord is absolutely right, my lord, but reservation is now happening in Supreme Court also, my lord.
My lord, may I, my lord, only take 1 minute, my lord? My lord, only one.
Please allow us to reflect.
My lord, may I hand
What
over
is
just
reserved
notification? My
notification?
lord, only 1 point, my lord.
We will have to work it
My
out.
lord, 30 seconds, my lord. My lord, 30 seconds, my lord. Only 1 point, my lord. My lord, may I hand it over just 2 notification, nothing more, nothing less.
Very well. Give the notification.
May I hand it over this?
We will consider.
One is state conduct guideline and another one is extension.
Written forest matter.
My lord, only one line.
Your Lordship, just to.
One thing, minutes I wish to
My lord,
find
can you
out.
consider that
Lordship, I wish
extension?
also
Extension. Nothing more, nothing less.
May I make a limited
submission
only on the retrospective effect?
He will look into
Your Lordship.
since whatever points are there. Our notes are ready.
Your Lordship, Lordship, may I-
Lordship, very important
Lordship,
2 points
submit
which
one
is
thing.
already concluded in the entire matters, Lordship.
Your
One
Lordship.
first is there, give the Lordship the time to the teacher eligibility test for, and second is there, Lordship, very important,
We will
the
consider.
attempt,
Your
Lordship.
Lordship.
Give the attempt to the more
Your
than
Lordship,
one to
may I
more
just
than.
submit about
What is
Jammu
the
and
text?
Kashmir?
Very important. Physical education and the music teachers is not considered under the act of the TET examination. In this, Lordship,
Sharma ji, bulaiye bhai.
please,
Your Lordship.
one sentence, my lord. My lord, they are, my
Your
lord,
Lordship,
the
may I
teachers
just-
are ready to. We are appointees prior to 2009. We are ready to give the TET test. Only we should be given promotional post also, and if we fail, my lord, we will lose the service as well as promotional post. That is only what our content is there.
And I seek permission to withdraw 301.4.
Forest. I'm for the promoter. No, first, today we'll hear Mr. Fernandez, Madam, and Mr. Prasad.
Only last time, Lord, you all should issue notice in my application.
Wait a minute. Get all the DC and the.
I know, so
that on video.
that report has come, Lord, where they say that they have 400 crore around.
No, not that. Not that 400 crores. Whether they have taken.
Oh, I see the deputy commissioner. Lord, at some stage, your lordship will have
Your Lord. Yes,
here the surplus. Where will the surplus go? That hearing your lordship will have to.
there is a minutes of meetings that we filed yesterday because we were to. Yeah, we have hard copies. We have hard copies. Just hand it over. Your Lordship. Yes, so we've given the modalities, my lord. We are very sorry. Your Lordship directed us 48 hours before. Yes, so therefore, my lords, SBI CAPS is going to be the agency which is going to conduct it. Yes. And they have given a detailed timeline, a detailed schedule in terms of various steps to be taken. Your Lordship straight away comes to para 6, para 5 onwards, page 3. Page 3, Lords, para 5, there's a common consensus, Lords. We spoke to income tax, SBI caps, the Hyderabad office, the GFIL committee, and the amicus. So SBI caps, Lords, will be at para 5, the agency tasked to conduct the auction. At para 6, Lords, auction would have 3 phases: pre-auction phase, actual auction, and number 3, post-auction modalities. If your Lordship kindly comes to para 7 at page 4, we have given the various stages, the respective milestones. So on the left-hand side, Lords, phase 1, pre-auction. So in that, there are 3 steps. The first step is receipt of necessary information, because we have clarified that below. What is that necessary information? That shall be the starting point, T0. That will how the limitation starts. And everything will have to be given to SBI caps. After they receive at serial number 1, then at serial number 2, SBI caps will prepare the model tender documents and the RFRP, request for proposal, the bid documents that they will prepare, which they will take 60 days. So T plus 60. And then number 3, approval of the RFRP and the reserve price lots, that the income tax department and the Golden Forest Committee together will assist your lordships in that. So this is stage number 1. Stage number 2 is the tender approval from the department. So once
just 1 minute, Mr. Fernandez.
I'm so sorry.
Report of the committee, this exercise will have to go later. I'll tell you, Lordship, why. The report of the committee says it has got 404 crore with it. Verified claims is only 200 crore. Rest are all unverified claims. Let them. So unverified means where checks have gone and returned, or checks have.
If there's surplus with the company, it will remain with the company.
No. So other means. No. But why should it be this piece put to sale if the money already with the company is more than not sufficient to be?
If the company is to be liquidated and it has gone to liquidation.
It's not to be liquidated. I'll tell you, Lordship. So this is a matter where just give me 5 minutes, 2 minutes, Lord. This matter is a matter where at all points of time, right from 98 onwards, 2006 on affidavit, Lord, it has been always disclosed that the assets of the company have always been more than the deposits taken from. No case of diversion, no case of money laundering. It's only a question of Lord SEBI saying that you had not registered with us, and because of which Lord SEBI imposed the restriction. 86 to 98, company has been servicing every Lord depositor without any default. Today there is there is no issue, Lord, with regard to any default.
That cannot be. This company has been lying before us for how many years?
No. I'm talking prior to 20 years. I'm talking of 98, which is 30 years.
Just wait. We'll have to go through this.
No, I'm just giving, because if your lordship get into this exercise, if there is enough money already with the committee Lord has already worked for about 20 years.
Who are you appearing for?
I'm for the original promoter, Lord. I hold 72% of the shares. I've been there. I've been appearing in this. I've been what will happen today, Lord? Today the property value is Lord 4,800 crores.
Submission that I'm contesting.
No, but there has been no. There is a 2006 order. There is a 2006 order. Can I just? So she can't just start in between. I'm still continuing, Lord. There is a 2006 order where your lordships have taken a view that how will the surplus be dealt with has to be decided by this court. That has never been decided by this court.
Once there is.
No, but why should there be more money if there is already enough money lying in the committee?
Company is dead today. Who's functioning?
No. The company. There is no liquidation order. Please appreciate.
There has to be.
No, there is no liquidation order. Your lordships have transferred everything here.
Yes, it will stand liquidated. Only principal interest.
Even if it is, let me assume, even if it is liquidated, ultimately.
We'll give it to the shareholders.
So I'm holding 72%.
You'll get the money in case
So
you entitled to it. They will definitely.
I'm only saying, Lord,
shareholder will get it.
Your lordships are not doing a liquidation proceedings. Please appreciate.
20 years the company has not been functional. The company is
because of SEBI. 98 SEBI interdicted the company from doing anything further. And there is a restraint order operating.
Whatever it may be, the company is non-functional for last 20 years.
Because of SEBI, Lord, because of SEBI.
Whatever it may be, Mr. Singh, it will have to be struck off the rolls.
It
The
is
company
not, Lord,
functional
please
for 20 years.
appreciate. It is all under Lord interim orders that this is all continuing.
This argument does not appeal to us.
Your Lordships are not doing liquidation. Your Lordships are only dealing with Lord the claimants. And your Lordships have been actually extending. The last date that your Lordship extended was Lord July of 2025. Now, July of 2025, all the claims that have come, they say is only not going to maximum. Unverified claims also will take it to another 160 crore as against what money they already have. 160 crore is all that is required. So why should the company go in liquidation? The liquidation order has not been passed till date. So sometime your Lordship will have to hear us as to whether what will be the status of the original promoters or the shareholders, so to say.
Well, we'll have to decide the promoters.
No, I'm only saying give some hearing. Give some hearing. No, the liquidation. Just see, there is no liquidation order passed.
Investor forum. It was my application that 2018 this court directed that at least 70% of the principal amount should be disbursed. Was disbursed. Now only 30% is to be disbursed so that at least principal amount is disbursed to the investors who are traceable. But 30% is stated report says that only about 200.
No, see, but the problem today is,
and they have 400.
No, see, Mr. Singh, it doesn't work like this. Suppose there are 100 shareholders. You cannot say that 30 are traceable, 30 will get their entire money.
Shareholders, depositors.
Whatever it is, out of 100 depositors,
50,000 investors are traceable.
No, but how many are there? How many is the total?
No, your Lordship.
Total figure.
No. So to decide, one second. Let me explain, Lord. Let me explain.
How many investors do you have?
Let me explain, Lord. This is a matter.
24 lakhs. Approximately 24 lakhs.
This is a matter. This is a matter which has engaged the attention of this court. In 2006, your Lordship gave a cut-off date. Anybody has to apply by that cut-off date. Only is to be considered to be an investor. Thereafter, your Lordships extended that date to July of 25.
The Act does not work in that manner.
No, but your Lordships have rejected claims of people who came after the cut-off date. High Court has a rejected claim of people who came after the cut-off date. It can't be only to ensure of the committee.
Go to the Investor Protection Fund.
Just see the affidavit of the committee. Just see the affidavit of the committee, Lord.
Please examine it, Mr. Singh.
No, I'm saying just see the affidavit.
Forget the committee and us. See, we are all governed by law.
No, but the committee has. No, there is a date by which people have to come and make a claim.
So, if the claim is not made, the money will go to the central government.
It can't go to the central government.
There's an investor protection fund.
But there has to be some investor first for that purpose.
Sara, 75%.
There has to be an investor. And supposing there is an investor who makes a certain amount of claim, it can only be.
Just wait. First of all, where is the state? Yes, ma'am. Your officers are online. Yes, ma'am. Please ask them. Yes.
Mr. Anurag.
Good afternoon, sirs. Good afternoon, sirs. I am Anurag, District Collector, Yadadir Bungay District, sirs. Sir, as per the direction of the Honorable Court, we have complied with the direction. I have filed my report also, sir. We have erected boundary stones. We have displayed display name boards. We have kept the entire scheduled property under a prohibited list. And in addition to that, every month we have formulated a team which will check every month whether the instructions are being complied or not, sir.
And you have issued directions to the registry not to register any sale?
Yes, sir. Yes, sir. We have issued directions and the registration department has also kept it in the block list, sir. No registrations can happen, sir.
You're right. And you have also instructed the police?
Yes, sir. We have written to the police for protection.
1st of May. It includes the photographs and the fact that the action taken in para 3.
Yeah.
Para 4.
30 seconds.
Binding of order will involve. Judicial proceedings will start later upon. I know, I've seen that. No, the 22 was this. Not pictures. 22, yeah. Okay. Just see the committee's latest affidavit. That will make things.
We'll hear you. We'll hear you. But this, we're just pointing out, we also consider the statutory provisions.
Yes. I'll show investors fund. What is it meant for?
Yes.
And whether it will apply in this case or not.
Yeah. Suppose there are 100 depositors. If 30 come to court, We cannot say that 30 will get the entire money and 70 will get
No. So who is a depositor is to be decided. Either somebody makes a claim or there is some record of the company.
The record will indicate how many investors
So
are.
that on the basis of that record, your lordships gave several.
You were saying 24 lakhs. Someone said 24 lakhs.
Yeah, 17 lakhs.
All that it is a small amount. So all that results in 400 crore only. That's all.
What about the interest? You're not factoring.
No, I'm saying give them interest also.
18% minimum.
For 9 lakh. The affidavit that we have received, and everyone we are telling you, the affidavit which has just been given to us by the amicus curiae states that he has to take some preliminary steps which will take about 60 days. Right? That is collating of information. I think we'll allow them to go ahead with the first stage, that is of 60 days collecting of information. In the meantime, we'll list this matter immediately at the reopening.
For this purpose only.
Whatever you want to argue, please argue.
No, your lordship will give us some time for the, not like this, so that we should at least, lordship, how the litigation has proceeded.
Whatever you want to argue.
Before that,
I just one
para
submission
9.
to make.
No,
I
para
have
9. The para 9, there's a tripartite.
submission to make.
That is the first step. Please see para 9. Please see para 9.
Just to
that is how it
facilitate
starts.
this, Milord.
So
This
first,
is
there has to be an
important.
agreement where SBI Caps is onboarded. This is at para 9. So SBI Caps has this precondition that please sign an agreement first. So at para 9, there is a tripartite agreement between Income Tax, Golden Forest Committee and SBI Caps. They three will enter into a tripartite agreement first. And once that tripartite agreement is arrived at, the relevant documents will be given to SBI Caps, which will be ground zero.
Milords, I have one more submission to make. As per the schedule given by SBI Caps and the Income Tax Department, in phase 1, there is a T0 phase, which, my lords, can be related to 11. They are collecting all information. So all valuation. Second thing is the site plans and demarcation reports. Since the district collector is here, my lords may clarify when this can be given. It's not necessary to really give it after the tripartite. It can be taken over by the Income Tax Department from the district collector. They can take it over. So para 11, at least this information should be made available.
May I just make one dictate? The district collector is here. We have filed an affidavit, last order records, the DBS laboratories, lordship has sent it at a later date. Now, no, whatever I'm saying is, they have said the physical inspection has been done. On affidavit, I have said nobody has come. Now, I've got photographs, I have not produced it, I can produce it. There's not a single boundary wall they've erected inside my, they say on the map it is encroached, not a single boundary wall is erected. So I, on affidavit, stated that nobody has come. It's a huge pharmaceutical company. Nobody has come, but in the map they say, it is, I don't know how they have got it. District collector is there, so lordship may, because
Thank you, stars that no post has been installed on your land.
maybe this will give them idea, but as of now, nothing has been done to the inside.
Lord,
So
my fresh IA notices can go so that the lordship can hear.
So we'll say, yeah, in short, what do you want to say? Today,
Does not include TET, but if your lordships have written this judgment, your lordship knows better what exactly it means. But that's my submission, my lords. The way I read it is that it does not mean TET, it means any other qualification that they don't have, they've been given a compliance period.
Thank you.
Then, my lords, just through 3 more lines, the sole object is to ensure uniform teaching standards across institutions, etc. We bow to that. My lords, you
ruling dispensation itself. In such circumstances, any appointment mechanism which confers exclusive or overwhelming control upon the executive gravely compromises both the actual independence of the commission and the perception of its neutrality. In institutions discharging constitutional, adjudicatory, and supervisory functions, legitimacy rests not merely upon actual independence, but equally upon the public perception of institutional neutrality. Even a reasonable apprehension that appointments are controlled by the political executive is sufficient to erode public confidence in the impartiality of the Election Commission. Constitutional democracy requires that not only elections be free and fair, but they must manifestly appear to be so. And then, my lord, Para 16, the impugned Section 7 creates a selection committee structurally dominated by the political executive, consisting of the Prime Minister and a Union Cabinet Minister nominated by the Prime Minister. The consequence of such composition is that the ruling dispensation effectively acquires decisive control over appointments of the EC. This creates a manifest danger of institutional bias, as the party, which is itself the principal stakeholder in electoral contests, is empowered to determine the composition of the constitutional authority charged with supervising those very elections. This court has consistently held that where one party to a dispute or process retains unilateral or dominant control over the constitution of an adjudicatory body, the resulting mechanism becomes constitutionally suspect, violating the principles of equality, fairness, and institutional impartiality under Article 14. Then, my lord, then came this case, Central Organization for Railway Electrification, which was regarding arbitration. And again, this is a Constitution bench judgment. I'll only read a few paragraphs. If your lordship turns to page 24, para 75. At the bottom, independence and impartiality of arbitral proceedings and equality of parties are concomitant principles. The independence and impartiality of arbitral proceedings can be effectively enforced only if the parties can participate equally at all stages of an arbitral process. Therefore, the principle of equal treatment of parties applies at all stages of arbitral proceedings, including the stage of appointment of arbitrators. Then para 88. The principle governing the doctrine of bias is that a member of a judicial body with a predisposition in favor of or against any party to a dispute, or whose position in relation to the subject matter or a disputing party is such that a lack of impartiality would be assumed to exist, should not be part of the tribunal composed to decide the dispute. This principle is applicable to authorities who have to act judicially in deciding rights and liabilities, and bodies discharging quasi-judicial functions. A quasi-judicial authority empowered to decide a dispute between opposing parties must be one without bias towards one side or the other in the dispute. A member of a tribunal which is called upon to try issues in judicial or quasi-judicial proceedings must act impartiality, objectively, and without bias. And then they say, my lord, at para 128, the highlighted portion, the underlined portion, a party may select a particular person to be appointed as a sole arbitrator because of a quid pro quo arrangement between them. Moreover, the fact that the sole arbitrator owes the appointment to one party may make it difficult to decide against the party for fear of displeasure. It is not possible to determine whether the sole arbitrator will be prejudiced, but the circumstances of appointment give rise to the real possibility of bias, and certainly, my lord, to a reasonable apprehension of bias. Equal treatment of parties at the stage of appointment of arbitrator ensures impartiality during the arbitral proceedings. A clause that allows one party to unilaterally appoint a sole arbitrator is exclusive and hinders equal participation of the other party in the appointment process of arbitrators. Further, arbitration is a quasi-judicial and adjudicatory process where both parties ought to be treated equally and given an equal opportunity to persuade the decision maker of the merits of the case. An arbitral process where one party or its proxy has the power to unilaterally decide who will adjudicate on a dispute is fundamentally contrary to the adjudicatory function of arbitral tribunals. And then, my lord, in the next paragraph, after about 8 lines, however, the problem arises when the PSUs make it mandatory for other parties to select the nominees from a curated panel of arbitrators. Here, my lord, both things are happening. It's not merely the curation is being done by the law minister and a couple of secretaries, but the selection is also being done by the government. When a PSU exercises its discretion to curate a panel, the very factor that the PSU is choosing only a certain number of persons as potential arbitrators and not others will raise a reasonable doubt in the mind of a fair-minded person. The PSUs may conceivably have nominated a person on the panel of potential arbitrators because they have a certain predisposition in favor of the former. This doubt is reinforced when the other party is given no choice but to select its arbitrator from the curated panel. The possibility of bias is real in situations where arbitration clause allows a government company to unilaterally appoint a sole arbitrator or control the majority of the arbitrators. Since the government has control over the arbitral tribunal, it can chart the course of the arbitration proceedings to the prejudice of the other party. Resultantly, unilateral appointment clauses fail to provide an effective substitute for judicial proceedings in India. Further, a unilateral appointment clause is inherently exclusionary and violates the principle of equal treatment of the parties. And therefore, my lord, they lay down the following, this is the decision at page 28. In view of the above discussion, we conclude that the principle of equal treatment of parties applies at all stages of arbitral proceedings, including the stage of appointment of arbitrators. The Arbitration Act does not prohibit PSUs from empaneling potential arbitrators. However, an arbitration clause cannot mandate the other party to select its arbitrator from the panels curated by the PSUs. A clause that allows one party to unilaterally appoint a sole arbitrator gives rise to justifiable doubts as to the independence and impartiality of the arbitrator. Further, such an unilateral clause is exclusionary and hinders equal participation of the other party in the appointment of the arbitrators. In the appointment of a three-member panel mandating the other party to select its arbitrator from a curated panel of potential arbitrators is against the principle of equal treatment of parties. In this situation, there is no effective counterbalance because parties do not participate equally in the process of appointing arbitrators. The process of appointing arbitrators is unequal and prejudiced in favor of one party. And then they say unilateral appointment of arbitrators, unilateral appointment clauses in public-private contracts are violative of Article 14 of the Constitution. So therefore, my lord, irrespective of, even if, my lord, your lordships had not delivered that Anup Baranwal judgment, even if the Anup Baranwal judgment was not there, and if we had come to court afresh, de novo, to challenge this particular act, clause 7 of this act, in my respectful submission, my lord, the same arguments would apply which persuaded the court in Anup Baranwal's case, which persuaded and which have persuaded, my lord, 4 other constitution bench judgments of this court in other cases involving either selections to the judiciary or selections to tribunals or selections of arbitrators. And then, my lord, I just want to read the last page 32. This is my submission. It is submitted that though by way of the impugned section, the vacuum under 324(2) of the Constitution has been filled, however, the impugned section does not alter the second basis, that is, appointment of members of the Election Commission should not be in the exclusive hands of the executive. The impugned section restores the earlier position in law. Appointment of the Chief Election Commissioner and election commissioners would be done solely by the executive. This is because the selection committee is ex facie dominated and controlled by members of the executive, that is the Prime Minister, Union Cabinet Minister, etc. In such circumstances, the legislature by the impugned section has not removed the defect which the court had found in the previous law, and as such, the impugned provision is liable to be struck down by this court. As I said, my lord, even if this court had not delivered that Anup Baranwal, the same argument would apply. It is respectfully submitted that this court in Anup Baranwal, while expressly observing that its directions would operate until a law is made by Parliament, did not leave the field open to unfettered legislative, even if it is assumed that it was left to unfettered legislative discretion. As I said, the same arguments will apply. The same arguments which persuaded the court to issue those directions, mandating to fill up in the interregnum a committee of Prime Minister, Leader of Opposition and the Chief Justice. They said that the arguments which persuaded the court and which they said stated in their judgment were that, look, if you leave this election in the hands of the executive, it creates bias of the election commission, which is performing many. Firstly, it has enormous power. Secondly, it is performing many quasi-judicial functions, and clearly the government or the ruling party is a very important, the most important player in all that, and therefore it will run contrary to that. So therefore, my Lord, it is respectfully submitted that this court in Anup Baranwal, while expressly observing that its directions would operate until a law is made by Parliament, did not leave the field to unfettered legislative discretion. The Constitution bench, in deference to separation of powers, issued interim directions upon recognizing a constitutional vacuum, but simultaneously laid down as a binding constitutional principle under 141 that the Election Commission cannot be placed under the exclusive or dominant control of. Actually, I should have said that the selection of the Election Commission cannot be placed. This holding rests on the foundational principle that executive dominance in appointments to the Election Commission imperils free and fair elections, which form part of the basic structure. Therefore, while Parliament could fill the vacuum, it could not reintroduce the very defect identified. And it's not just a defect identified, it's a defect which is founded on several fundamental principles, that is free and fair elections, democracy, rule of law, Article 14. All those were foundational principles on which the court's judgment was founded. So it's not merely a defect which they pointed out, but the defect was on the basis of so many principles of the Constitution. The impugned provision, by restoring executive dominance, substantially defeats the ratio of Anup Baranwal. So I am not just basing my arguments on Anup Baranwal. I am saying that dehors Anup Baranwal. Even otherwise, all those principles which the courts have enunciated with the Constitution benches of this courts have initiated, has enunciated in so many judgments. Scora 1, that Scora 2, that is NJAC, then this Roger Matthew, then that Central Railway Organizations on Arbitration Tribunal. Exactly all those principles apply squarely to the facts of this case. And therefore, my Lord, in my respectful submission, this needs to be struck down. And as I said, my Lord, my fear is
we can't do.
No, your Lordship can do something. Can do. So your Lordship can now go one step further. So one step further. I'm not saying that your Lordship should prescribe exactly what should be the law made by. I'm not saying that. What I am saying is that your Lordship can say that whatever body they make cannot have people whose appointment in turn, or if they have people whose appointment in turn depends upon the executive, that will vitiate the same principle. So, for example, the Speaker, the Vice President, their appointment is squarely in the hands of the executive. So, therefore, that your Lordship can, and in my respectful submission, should say, because otherwise we keep coming back to square one. And that's what happened in that Madras Bar Association case also, where this court repeatedly gave directions. They repeatedly came back with the same or similar rules, etc. So therefore, in order to avoid that, in my respectful submission, your Lordship should go one step further, one step beyond Anup Baranwal, without specifying the exact law or the constitution of the selection body. I am very grateful to your Lordship.
ये फोल्डर में this Which is your writ?
Milord, my writ petition is.
I forgot to mention.
Yeah.
Your Lordship has laid down a principle that if a law is struck down, then all the acts done under the cover of that law also go unless the court specifically says prospective overruling. Without that, the principle is that all the acts, therefore all appointments made under the cover of that would automatically go. I'm grateful.
Lord, I am appearing in writ petition number 191 of 2024, UCL, this is Union of India.
UCL.
UCL petition.
This is 34 point?
34.4, I think. 4. Lord, UCL has taken up this as a forefront, my Lord, that the electoral reforms are absolutely necessary. And that's why Lordships have those 2 or 3 judgments which have been referred to you umpteen number of times, that about the assets to be declared, nota, etc. Yes, Lordships want to see my prayers.
This one, Mr. Bhushan is there?
Yes.
Please cure your defects in the petition.
Yes.
We'll make a note
At page 20.
Yeah, just 1 minute.
Done by tomorrow.
The then learned counsel for Franco has concluded his arguments. In course of hearing, it transpired that the deponent who affirmed the affidavit in support of the petition has since passed away.
Verification clause.
He has since passed away. In view thereof, as well as the fact that the verification clause is defective, we permit the petitioner to have the pleadings supported by an affidavit, by a fresh affidavit, as well by a present functionary, as well as cure the defects in the verification clause by tomorrow.
Of course, I won't be able to cure that defect. I can.
No, the para numbers which are blank.
Actually, it was just because the verification only affirms the.
True, but you have to fill it up. You cannot give a blank portion to the court.
I agree.
Sir, what are your prayers? Let us.
Yes, page 27. Questioning, my Lord, the
Section 7.
7. And then also, my Lord, sought regarding the same thing, declaration, which is actually very general in nature.
Right.
So that's how it is. And the affidavit, I suppose, is, my Lord, we have filled up the paragraphs and everything.
Filled up.
28 Lordships will look at that, because if I have to cure something, I'll cure it. I think everything is, my Lord.
Yes.
Yes.
This one has it.
Yes. Lord, at the outset, I must say that the issue which is involved in this matter is of the utmost, my Lord, importance today. Because if you are talking of democracy, democracy can be sustained only, my Lord, if there are free and fair elections. And the free and fair elections are possible if you have an independent election commission. So therefore, my Lord, I don't think anything is more important, any of those cases, than this particular case, my Lord, because on this, the fate of this case, my Lord, the democracy ultimately, the fate of democracy will depend. My Lord, I have prepared only 2-page propositions, which I'll explain to your Lordships, not a very detailed one, because just give a copy. My Lord, basically, if you look at the arguments, we are concerned, my Lord, with 2 issues. Number 1 is, my Lord, if you look at Baranwal, which is a constitutional judgment, so many paragraphs have been read out to your Lordships, whether this particular legislation can be struck down on the ground that this is violative of the constitutional judgment, in particular the separation of power. And also Baranwal has used, my Lord, at places, Article 14 and 19, to sustain that if it is not free and fair, the independence is not maintained and it is not free from the executive influence, then it will violate Article 14. 19 also, because 19 is a right which is given to the voters to cast their vote, my Lord, independently. That's, my Lord, one point. The second one is whether independently also, which Mr. Bhushan also pointed out, that this is violative of Article 14, and 19 of the Constitution. So these are basic two questions, my lord, which are before your lordships. Now kindly have a look at, my lord, my note, which my lord, I'll read few paragraphs from Baranwal. Then, my lord, there is a compilation. There are 2 or 3 judgments which I'll read, my lord, few paragraphs from that. That will end my submission. I just want to point out the contours of the independence of Election Commission as a constitutional body is essential. Only an independent commission can ensure the rule of law, equality and conduct of free and fair elections, which are the hallmarks of a vibrant democracy. Therefore, the process of appointment of election commissioner must ensure independence of election commission, freedom from any executive interference. And these are the 2 things which have been pointed out, my lord, in Baranwal's case repeatedly. Independence, something which is the crux of the entire thing. In the process of appointment, law enacted permits executive interference and does not ensure the election commission's independence. It will be violative of Article 14 and 19 of the Constitution. It will affect both free and fair elections and the right of voters under 19. It will affect the rule of law and democracy. Now, these submissions which are made, my lord, are based on the interpretation which are given to Article 324 in Baranwal's case. Now we go, my lord, I'll explain it later on. I'll just read, my lords, my other points and then come to the observations, findings given by the Constitution Bench in Baranwal are binding. The impugned statute has overruled, set at naught, the Constitution Bench judgment of this Honorable Court, which is not legally permissible. The court's interpretation of the constitutional provisions is binding. And if enacted statute is not in conformity with that interpretation, it can be struck down. So it's, my lord, not only the directions which are given, the interpretation to the Constitution which is given, which is binding, which, my lord, I'll point out from the judgments. And therefore, my lord, it is not something which is permissible. Transgression of constitutional limitations and intrusion into judicial power by the legislature is violative of principles of separation of powers, the rule of law, and Article 14 of the Constitution. My lord, I have given all the judgments. I'll read only a few of them. I have given paragraphs also. This is, my lord, with regard to Baranwal, the first argument which I raised, my lord, that it is something which is violative of the law laid down or constitutional interpretation given in Baranwal's case. The second one is an independent one. An impugned legislation is also violative of 1419. An election commission that is not independent would fail to adhere to the guarantee of equality under 14 of the Constitution in holding the polls and treating the political parties with an even hand, thereby acting unfairly and arbitrarily. This will also affect the right of voters, which is recognized as a facet of Article 19 of the Constitution. Must mention, my lord, that we have gone through a number of judgments. Wherever, my lord, there is a overruling of the judgment which is given by this Honorable Court or any court, then they go basically on the principle of separation of power and rule of law. And number of judgments, my lord, say that it is void ab initio because it affects, my lord, the basic structure, the separation of powers and rule of law. But the subsequent judgments which have come, which I have quoted here, mention not only this because separation of power ultimately is a facet of Article 14. So they have said it will also violate Article 14 of the Constitution. Now 3 or 4 judgments recently mentioned that. One of them is, my lord, this Madras Bar Association. I'll read certain passages from that. Now before, my lord, I come to that, let me come to the first argument about the Baranwal and certain paragraphs, my lord. If I repeat anyone, lordships may point out to me that I'm repeating, I'll not read that particular para. Which is, my lord, the first proposition, first, second, and third, that it will be violative of because it takes away the independence and executive interference. Violative of 1419, affecting free and fair elections, the right of voters, and rule of law and democracy. These are the 3 principles which have been laid down, my lord, in the case of Baranwal. Now kindly come, my lord, to para 213. Yes. But it is, I am told in volume 1, and I'll just get the page number.
233.
233, my lord.
213, 214 have been placed.
Have been placed. So, my lord, if they have been placed, then I'll not place them. Then I'll come to, my lord, as I said in the beginning itself, if anything has been read to your lordships, my lord, I'll not read that.
215 has not been read.
Yes.
You can place 215.
1 second.
215 has been.
Where's my note? Is my note gone? Yeah. Yeah. Yes, my lord. Then I want to read, my lord, 218, para 218. 218, my lord, at page 235. Now, even if I read, my lord, one para, that will be enough because that is 218. Kindly just have a look at 218. The cardinal importance of a fiercely independent, honest, competent, and fair election commission must be tested on the anvil of rule of law, as also the grand mandate of equality we expedite. Rule of law is the very bedrock of democratic form of governance. It simply means that man and their affairs are governed by pre-announced norms. It averts a democratic government brought to power by the strength of the ballot betraying their trust and lapsing into government of caprice, nepotism, and finally despotism. It is the promise of avoidance of these viruses which persuade men to embrace the democratic forms of government. An election commission which does not ensure free and fair poll as per the rules of the game guarantees the breakdown of the foundation of rule of law. The submission which I made is that. Equally, the sterling qualities which we have described, which must be possessed by the election commission, are indispensable for an unquestionable adherence to the guarantee of equality in Article 14. In wide spectrum of powers, if the election commission exercises them unfairly or illegally as such, as it refuses to exercise power when such exercise becomes a duty, it has a telling and chilling effect on the fortunes of political parties. Inequality in the matter of treatment of political parties who are otherwise similarly circumstanced unquestionably breaches the mandate of Article 14. When we look at, my lord, these observations, I'm just stopping, we'll have to see whether these things have been answered there, because this is a part of constitutional interpretation, the interpretation which is binding. It says it will be a validity of 14. So if it is not independent, then on the face of it, it is violated to Article 14 of the Constitution. Naturally, the rights of the voters are affected because they have to, my lord, vote out of their own conscience. That's, my lord, 1918. It was preserved in QCL judgment. If that is taken away, ultimately, 19 is also violated. Now we come to, my lord, 222.
This was also read.
It was read. No, whichever, my lord, lordships want to, because I'm not going to read, my lord, repeat another.
The same thing becomes slightly.
It says election commissioners, including chief election commissioners, blessed with nearly infinite powers, who are to abide by fundamental rights, must be chosen not by executive exclusively, particularly without any objective yardstick. We may not skip that and kindly come to.
That is also placed 248.
My lord, lordships, yes, lordship, 248 to 253 must have been placed. I am not reading it. Yes. Now I come to, my lord, there are 279. If that is not read. My lord, that may be slightly important because I'll just point out what I wish to. 257. Now, Mr. Bhushan, 257. Read out, my lord, from the Supreme Court Advocate on Record Cessation, that para 279. Now, that is something important. When the Constitution was being drafted, there was general agreement that the appointments of judges in the superior judiciary should not be left to the absolute discretion of the executive. And this was the reason for the provision made in the Constitution imposing obligation to consult the Chief Justice of India and the Chief Justice of High Courts. This was done to achieve independence of the judges of the superior judiciary, even at the time of their appointment, instead of conforming it only to the provisions of security of tenure and other conditions of service after the appointment was made. It was realized that the independence of judiciary had to be safeguarded, not merely by providing security to tenure and other conditions of service after the appointment, but also by preventing the influence of political considerations in making the appointments. if left to the absolute discretion of the executive as the appointing authority, it is this reason which impelled the incorporation of the obligation of consultation with Chief Justice of India and Chief Justice of High Court under 124. 2. The Constituent Assembly debates disclose this purpose in prescribing such consultation, even though the appointment is ultimately an executive act. Then, my lord, lordships may skip that, and then taking, my lord, that on 326, that is about 282 para, it will again notice that Article 324(2) does not provide for consultation with anyone, and it appears to place the power to make appointments exclusively with the executive, as the President is bound by advice of the Prime Minister. However, it is precisely to guard against the abuse by exclusive power being vested with the executive that instead of consultative process being provided, Parliament was to make a law. This clearly was the contemplation of the founding fathers. Milord 384 is again, it is further greatest moment that the court noted in Advocate on Records as case. It was realized that the independence of the judiciary had to be protected not merely after appointment, but during the process of appointment, which I read out to lordships. The same principle, my lord, applies as regards, my lord, the Election Commission. Then lordships may come to 297. Yeah. I think this is, we have set down the legislative history of Article 324, which includes reference to what transpired, which in turn includes the views formed by the members of subcommittee and members of Constituent Assembly. They unerringly point out to one conclusion: the power of appointment of the members of the Election Commission, which is charged with the highest duties and with nearly infinite powers, and what is more, to hold elections not only to the central legislature but to the state legislature, was not to be lodged exclusively with the executive. It is accordingly that the words subject to any law made by Parliament were undoubtedly incorporated, that the executive interference should not be there. That was not the purpose. Now, lordships will look at 301. Your lordships, this has been read. I'll not read it. May I read, my lord? 301.
Even 301 has been
302, 303, my lord.
303, 308, 309.
305 is not read, probably that may be little. 308 is important, my lord, because 308 talks again by, my lord, if lordships permit me, I'll again read 308 only, not the other.
This has been read by both Mr. Acharya and
but
Mr.
My lord, just to point out to lordships, I'll not read it. It is only to point out that ultimately when they talk of, my lord, that should be independent and free from executive interference, they bring it under Article 14 and 19 of the Constitution. Just to point out to lordships that this is the importance of reading this particular.
Your submission is this, that apart from stressing on the need for a law to be framed under 324, the five-judge bench articulated its reasons why it should be free of executive control.
Because this will ultimately bear on, my lord, the constitutional principles and also the fundamental rights, Article 14 and 19. Therefore, the interpretation which was given was based, my lord, on the constitutional principles and fundamental rights, how they are going to be affected if there is no independent election commission. So, my lord, that takes care of my first argument. Now, my lord, come to the second argument, which is, my lord, that why these directions which are given are binding. I'll just give the compilation. My lord, I have given number of judgments, which I am not going to read because I have given the paragraphs. There are only 3 judgments. PUCL has been read to your lordships, but I would like to read PUCL from a different perspective. PUCL judgment, my lord, because I happen to appear in that matter. PUCL judgment.
We mark it as volume 6.
Right? PUCL judgment, my lord, came in the wake that how do we ensure that a voter votes according to his conscience and choice. That is his right, my lord, under 19(1)(a) is preserved. And for that purpose, the court said it is necessary that the criminal antecedents about his wealth, etc., there should be declaration. That, my lord, was the initial thing. Then came the law. And the law was, my lord, challenged in the PUCL judgment. Just kindly have a look at page 37, page 23. Page 21, Lordships will just look at. For the directions which are issued in Association of Democracy, it is contained. Some of them are incorporated by statutory provisions, which has been provided, not required to be disclosed or furnished, despite the directions issued by. Therefore, the aforesaid section 33B is under challenge. That is, my lord, para 8. And then, my lord, there are preliminary observations which have been made, even relying upon, my lord, Keshavan Bharati's case. All the constitutional interpretations, just 23, my lord, have political consequences should not obliterate the fact that the decision has to be arrived at in the calm and dispassionate atmosphere of the courtroom. And judges, in order to give legitimacy to their decision, have to keep aloof from the din and controversy of politics, and that the fluctuating fortunes of rival political parties can have for them only academic interest. Their preliminary duty is to uphold the Constitution and the laws without fear or favor, and in doing so, they cannot allow any political ideology or economic theory which may have caught their fancy to color the decision. Then, my lord, the submissions have been mentioned. Kindly come, my lord, to page 37.
Para?
Page 37, my lord, I'm just. Page 37, para 33.
Yes.
Now, this is, my lord, this was the argument. The learned counsel for the respondent submitted that by the impugned legislation, most of the directions issued by the court are complied with, and the vacuum pointed out is filled in by the legislation. It is their contention that the legislature did not think it fit that the remaining information is directed by this court is required to be given by a contesting candidate. This was the argument. This submission on the face of it is against well-settled position. In number of decisions rendered by court, similar submissions is negative. Legislature has no power to review the decision set at naught except by removing the defect, which is the cause pointed out by the decision rendered by the court. If this is permitted, it would sound the death knell. Rule of law is observed in Tii-Sc, etc. Then all these judgments are given, my lord. Lordships may skip them and come to para 37, page 40. Now, my lord, this interpretation was given by the court on the basis of 19(1) of the Constitution. Like we read just now, the interpretation which has been given to 324 is on the basis of, my lord, the constitutional principles. So, what the court said, for the purpose of deciding these petitions, the principles emerging from various decisions rendered by this court, inter alia be summarized thus. The legislature can change the basis on which a decision is rendered by this court and change the law in general. However, this power can be exercised subject to constitutional provision, particularly legislative competence, and if it is violative of fundamental rights under Part 3 of the Constitution. Such law would be void as provided under 13 of the Constitution. The legislature also cannot declare any decision of the court of law to be void or of no effect. As stated above, this court has held that 19(1)(a), which provides for freedom of speech and expression, would cover in its fold the right of the voter to know specified antecedents of the candidate who is contesting election. Once it is held that a voter has a fundamental right to know the antecedents of the candidate, that fundamental right under 19(1)(a) could be abridged by passing such legislation only as provided under Article 19(2), which provides as under. So, legislative competence to interfere with the fundamental rights under 19(1)(a) is limited as provided under 19(2). And this is very important because this is what, my lord, the test which has been laid down, that you have to ultimately point out that if you want to curtail a particular fundamental right, it can be only under 19(2). It cannot be on any other basis. So, therefore, if you want to do something here, you have to point out some constitutional provision that the independence is not a part of it, free from executive influence is not a part of the constitutional. You have to point out, if you do that, then you remove the basis, otherwise you don't remove the basis. Now, my lord, very important argument is, my lord, 41, that's why I wanted to read it. Learned senior counsel Mr. Jaitley developed an ingenious submission that as there is no specific fundamental right of the voter to know the antecedents of a candidate, the declaration by this court of such fundamental right can be held to be derivative. Therefore, it is open to the legislature to nullify it by appropriate legislation. In our view, this submission requires to be rejected. There is no such concept of derivative fundamental right. Firstly, it should be properly understood that the fundamental rights enshrined in the Constitution, such as right to equality and freedom to have no fixed contents. From time to time, this court has filled it, the skeleton, with soul and blood and made it vibrant. Since the last more than 50 years, the court has interpreted Article 14, 19, and 21, give meaning and color so that the nation can have a truly republic democratic society. This cannot be undone by such an ordinance amended act. And my lord, they mention all the judgments. And after that, my lord, 45, just look at 44, that if this argument is accepted, what will happen to all the judgments? There are many other judgments which are not required to be reiterated. All these developments of law giving meaning to freedom of speech and expression or personal liberty are not required to be reconsidered, nor could there be legislation so as to nullify such interpretation except as provided under the exceptions to fundamental rights. Now, that is very important, because once you give interpretation on the basis of Constitution, you cannot nullify it. If 324 has been given a particular interpretation by this Honorable Court, my lord, by the Constitution bench, then it cannot be nullified in this particular way. Now, Lordships may have the second judgment, which starts from page 123. As Mr. Bhushan pointed out, my lord, that there were a number of judgments, my lord, with regard to the tribunals. And as I, my lord, this is the last judgment, I think, to 2026 to SCC 1. And I noted down, I don't want to, my lord, read that MBA 1, MBA 2, MBA 3, MBA 4, they were considered. And then, my lord, at page 138, this MBA 4 has been dealt with. Lordships may come to page 140, which is para 82. Several directions were given by this Honorable Court. Again, my lord, filling in the blanks that how the tribunals have to function. The validity of these provisions, as amended by 2021, was challenged in Madras Bar Session, hereinafter, on the ground of violating the principles of separation of powers, independence of judiciary, and being contrary to the directions issued in series of judgments from MBA 1 to MBA 4. In response, the learned Attorney General argued that Parliament is empowered to cure defects identified by the court through fresh legislation, and that its collective wisdom could not be overridden by judicial intervention. She maintained that determining the service conditions of tribunal members is a matter of legislative policy, warranting judicial restraint. Direction issued by the court in the absence of legislation, he said, are merely suggestions. And this is important. This is, my lord, are mere suggestions, not binding. He argued that a subsequent law cannot be struck down for deviating from such directions, and judicial review of the ordinance must be confined to the standard grounds of review applicable to the legislation. At the outset of his analysis, Nageshwara J, speaking for the court, noted that the directions given by the court and MBM are in the nature of mandamus. He struck down the first proviso of the amended 1814. It was held that the minimum age, we can skip that because that's all directions which are given. It is stated that the judgment of court in MB4 was frustrated by an impermissible legislative override. It was further directed that the Income Tax Tribunal appointments pursuant to 2018 advertisement be finalized by considering candidates up to age of such and such. The court in MBA 5 held that the second and third proviso to Section 184 regarding provisions of adequate housing, etc., was held. By no stretch of lordship, we skip that, the second part. Such directions were issued, I am reading the last line, to uphold independence of the judiciary, and it cannot be subject matter of legislative response. A mandamus issued by this court cannot be reversed by the legislature, as it would amount to impermissible legislative override. Therefore, the second proviso read with the third proviso be declared as unconstitutional. This is, my lord, one argument. And then second, my lord, another very important argument which they have raised here. This argument has also been raised in counter, which I am pointing out is also raised. Now, my lord, kindly come to page 145, para 94. The argument on basic structure theory, my lord, that if you are saying the separation of power, which is a part of basic structure, you can strike down a constitutional provision, but not the ordinary parliamentary law. That's my lord, the argument which was raised. Which, my lord, as I submitted, that when this court said, and that is very significant, that separation of power is something which is a part of Article 14 of the Constitution, which I read out to your lordship, my lord, which is also said in Baranwal. Then the question of, my lord, the basic structure that it can be struck down only on that ground doesn't arise. But in any case, my lord, the court has answered it. In his concurring opinion, Ravindra Bhatt J. dealt with the argument of Union of India that when a legislation or legislative instrument is questioned, its validity can be scrutinized only by considering its impact on some express provisions of the Constitution and not on any concept or notion such as separation of powers and judicial independence. He held the challenge to executive or legislative measures based on violation of the twin concepts of separation of powers and independence of judiciary have to be seen in terms of their impacts, not at one point in time, but cumulatively over a time continuum. In all these decisions, this court scrutiny was based upon its role as the guardian of the Constitution, and more specifically independence of the judiciary. If one were asked to pinpoint any specific provision of the Constitution that this court relied upon while holding the enacted provision to be falling foul of, there would be none. It is too late now to contend that independence of judiciary and separation of powers are vague concepts based on which parliamentary enactment cannot be invalidated. Then lordships may come to page 153. There are lordships may just mark it para 95, that Article 14, the equal protection, because that argument again comes up here. Para 95 at page 146. And Millard, I must point out page 153, Justice Hemant Gupta dissented. That 103 it is mentioned in that judgment. And then, my lord, the most important thing which I wanted to point out is, my lord, I have 150, 160, no? Page 160. Yeah, page 160, my lord. Page 160.
160.
160, para 121. My lord, 120 is, my lord, there was submission made by the Attorney General to refer it to larger bench, which was, my lord, overruled. So it ends there. 121. The second central contention advanced by the Union.
170?
Sorry, 160, para 121. I'm so sorry.
121, yes.
120.